do the needful with any electronic devices. There will be a discussion briefly just on the additional amendments to the Human Trafficking and Exploitation Act. That will be Hansarded. However, due to the volume of work this week, Hansard aren't able to cover the oral evidence sessions of the Bar Council and Law Society. The Committee Office has requested, though, a retrospective transcript of the briefings, and Hansard then will advise if they can accommodate this next week. So they can't do it now, but it is hoped they'll be able to do it on the basis of the audio and visual recording, and then we'll be able to get a transcript. There's apologies from Mr. Patsy McGlone. Item 2 is just the draft minutes of our meeting on the 10th of September, and if members are content with their accuracy, there was one amendment that Mr. McGlone requested to be made, which was on page 9, and it was item 13, which was proposals to vary firearms licensing fees and other miscellaneous amendments to the firearms legislation. The minutes state the committee agreed to request advance notification from the Department of Justice on the proposed engagement with stakeholders in relation to the firearms proposals. He wants to add, in order that members wishing to attend could do so, to the end of that sentence. I can certainly recollect Mr. McGlone making that point, so I'm happy that that would be an amendment made to the minutes. If members are content with that, then I'll sign it accordingly. Thank you. Some matters arising. The forward work programme for September and October has been provided in your meeting folder. As agreed last week's meeting, arrangements have been made for representatives of the Prison Officers Association to attend on the 15th of October in relation to staffing levels in Maghabra and health and safety concerns. Northern Ireland Prison Service officials will attend the following week on the 22nd of October to provide an update on the reform programme and the briefing on management of drugs within prisons, which was requested by the committee to take place on that date also. And an updated forward work programme will be provided at next week's meeting to incorporate items that were discussed at the informal planning meeting that took place just before this meeting. Agenda item 4 now is the legal aid reform. In May this year, departmental officials updated the committee on its engagement with the Law Society and the Bar Council regarding proposals to change the remuneration arrangements for solicitors and counsel representing defendants in Crown Court cases, and presented details of proposed statutory rules. Officials indicated that it had not been possible to reach consensus on the proposed changes. Following the oral briefing, the committee agreed representatives from the Bar Council and the Law Society should be invited to give oral evidence in relation to the proposals, and both organisations are here today. The relevant papers for members are pages 26 to 103 of your meeting folder, and a written submission from the Bar Council is on pages 3 to 18 of your table package. Just to advise members, you're aware the Criminal Justice Inspectorate has provided a short interim report on the work it has completed so far with regard to the legal aid reform proposals, and this is in your tabled pack, pages 46 to 53. So we're just in receipt of that. There's to be a final report provided from them at our earlier meeting over lunch. We agreed that we would invite the Criminal Justice Inspectorate to come before the committee once they've completed their final report. So we will do that, and that will help facilitate members on these important issues. So could I, at this stage, I'm going to invite the Bar Council representatives to come before the committee. Just as the representatives are taking their seat, to remind members it's pages 3 to 18 of your table pack as the Bar Council's written submission. Can I welcome to the meeting Gerald McAlinden QC, Gavin Duffy QC and Michael Ford, all from the Bar Council. And as always, gentlemen, you're all very welcome to the meeting.
Thank you very much.
We look forward to hearing from you, and obviously you're familiar with the format. You'll get into a brief outline, and then members will have the opportunity to ask some questions. So I'm going to hand over to yourselves at this stage.
Mr Chairman, I wish to thank the committee for the opportunity to come and speak to you today. This afternoon I intend to touch on some of the key issues, and then with the help of Mr Gavin Duffy QC and Mr Michael Ford, who both specialise in criminal law and practice predominantly in the Crown Court, we hope to answer any questions members may have. The Bar has constructively worked with the Department of Justice to ensure that criminal legal aid expenditure is brought into line with the budget, and we will continue to work with the Department to do so in order to ensure both value for money and quality of representation. The committee is familiar with this latest consultation in relation to the Crown Court, and you will also be aware that this is the second such proposal for significant cuts to this area of legal aid within this mandate. For us, the key issue in this matter is the proper administration of justice in Northern Ireland through the maintenance of high standards in both branches of the profession, in the service of their clients, and in the preservation of a system within which able and experienced lawyers continue to serve the public in all areas of publicly funded work. After extensive analysis and due consideration, we do not believe there is a proper or fair basis for introducing these latest proposals. Unfortunately, the impact of the 2011 rules is not yet fully known or understood. We estimate that over the next year, costs associated with the Crown Court will reduce further to a level significantly below that of 2012-2013. We appreciate that the committee and possibly the public at large may believe that this proposal simply affects solicitors and barristers. However, our concern is for the individuals that we encounter on a daily basis and our ability to properly represent and navigate them through the criminal justice system. The impact of such rule changes may seem remote now, but I can assure you that they will have a sharp impact on daily practice. It is important to appreciate that there are a number of significant factors currently influencing the profile and cost of cases in the Crown Court. Firstly, there's a 50% increase in the number of cases being concluded by the Crown Court between 2008 and 2013. Secondly, the appointment of a fourth County Court judge to clear the backlog of cases. Thirdly, the remaining very high cost scheme cases have been ebbing out of the system. And finally, the 2013 LSC amnesty to clear out all old Crown Court and Magistrate Court cases which have been completed in previous years has resulted in a huge number of cases being processed in 2013 but paid out in the financial year 2013-14. And there also another point to remember is that there's been a substantial reduction in the number of two council certificates. Bearing all these factors into, or taking all these factors into account, the Bar predicts that at the end of the financial year 2014-2015, the standard Crown Court expenditure on solicitors and counsel's fees, with no rule changes, will be approximately £3 million less than the 2012-2013 figures. Indeed, there are signs that the number of cases coming before the Crown Court is reverting to the levels last observed in 2010-2011. And if that occurs, one could in fact see savings of between £8 and £9 million without the need for the introduction of any further reduction in fees. By way of explanation, comparisons with England and Wales have been offered without a full appreciation of the critical differences not only in the fee schemes but also in the court systems, practice and the law. What is more concerning to us is the lack of awareness of the significant difficulties that have arisen in England and Wales as a result of similar proposals. Whether you choose to listen to judges, practitioners, the media or Westminster MPs, it is evident that the system is under massive strain. And this is not a situation we want to replicate here. Those appearing in the Crown Court represent barristers with many years of experience and expertise. Barristers face many years of uncertainty, particularly those who wish to undertake publicly funded work. Many are leaving the bar after a number of years. The loss of the brightest and best young barristers is a concern to us for the future of publicly funded representation. The bar fully understands the considerable pressures on resources in the current economic situation. We recognise the importance that is placed on other frontline services such as health and education. Too often, access to support in the criminal justice system is not considered worthy of equal protection. Our collective aim is to maintain and enhance access to justice. The reality which must be faced is the justice system is a demand-led service, and while every effort should be made to control budgets and spending, it is not possible to deliver these services while introducing changes that deny the public access to legal representation in their time of need. Imposing these cuts will further damage public confidence, undermine access to justice, and compound problems of proper representation in difficult cases. These issues are sufficiently important to deserve a properly considered approach. We remain confident that to meet budgetary expectations, it is not necessary to implement further cuts to the Crown Court, and believe that a clearer picture will emerge following the publication of data for this financial year, when the true cost of the existing rules will be properly demonstrated. Thank you for your time, and we welcome any questions you may have.
Thank you very much. I'll ask you a few questions and then I'll bring in members in due course. In terms of the reductions, and I note the paragraph 32 to do the current fee structure for Crown Court. It says that it works well, it's now within budget. I can recall at the time of the first reductions, there were predictions of how devastating that it would be to the legal profession and to those looking access to justice. And I'm noting that you're now saying that the current structures work well and provides value for money. Were the predictions that were made not actually then transpired with the reductions that did take place to introduce those fee structures?
Perhaps I can deal with that question, Mr. Chairman. First of all, I think our position is that the true impact of the cuts from 2011 really have not yet been seen. And in fact, there's a recent document which had been commissioned by the Department of Justice, which is entitled Access to Justice 2. And if you look at that document, I don't know if that's been supplied to the committee by the Department of Justice. But if you look at that document, on page 11, you will see a table of expenditure married up with the number of cases being disposed of by the Crown Court. And in fact, what it demonstrates is that whilst in 2010-11, that's the year these changes were brought in, there were a total of 4,673 Crown Court bills submitted, and the cost of those bills was just slightly over 36.8 million. In 2013-14, which is the last financial year ending in April, for a spend of significantly less, for a spend of 5 million less than that, there were a total of 7,529 bills submitted. So what in fact has happened is that this massive increase in productivity in 2013 and 14 has served to completely mask the worst effects of the 2011 changes. And what we're really saying is that members of the profession have increased their productivity by over 60%. In fact, I think the figure is probably close to 70%. We've put through 70% more business in terms of cases submitted for payment. And the reasons for that, I think, are set out in the document that I've supplied. And I don't think there's any dispute about that. But what we're now saying is that when you look at the number of Crown Court cases coming through the system, and this is information that's available from Crown Court judges, from Mr Justice Weir, the head of the Crown Court, from various PPS offices and other county court divisions, it does seem as though there is now a return to the level of Crown Court cases that we last saw, say, in and around 2010, 2011. And what is going to happen, we're on the verge potentially of a very significant tipping point where the real effects of the 2011 changes are going to be seen. And in fact, if you, for example, replicated the payment of the bills in 2010, 2011, those 4,673 bills, if you put those bills through at the current levels of remuneration, the cost in terms of expenditure would be somewhere in the region of about half of what was paid in 2010, 2011. So we in fact anticipate, first of all, that the real effect of the 2011 cuts has been to reduce, in real terms, remuneration to approximately 50% of what it had been. And we're also saying that whenever one returns to normal years of productivity, which we think is going to happen this year, that one will see a massive collapse in the amount of funding being spent on Crown Court cases. And it's that which we respectfully say will result in significant challenges to those providing those services, whether they be solicitors or members of the bar. And of course, we operate within systems with fixed costs. We provide the services that we do regardless of the amount of demand that is there for them. But if you suddenly find a severe reduction in funding, which we do anticipate will happen purely as a consequence of the previous cuts, that is bound to have a massive impact upon the profession and its development, and indeed the ability of the profession, whether it be solicitors or counsel, to provide the quality of representation which has been provided to our clients, your constituents, over the last number of years.
So, how come the Assembly voted through the reductions, established this fee structure? The workload then has increased significantly, and therefore that has somehow kept the representation then at a level that could manage the increased workload, but now that's going to dissipate somewhat.
So, yeah, what I'm saying is in fact that when you raise this issue about this prediction as to the devastating or potentially devastating effects of the previous cuts, what I'm saying is that you haven't seen that yet, because it has been masked by the fact that we, first of all, had a significant backlog of cases over the last number of years, which have largely been cleared out in 2013-14. We had a legal aid amnesty, which is something which had never been encountered before, where they were endeavouring to clear out cases that had been concluded previous years but had not been submitted for payment. And we also had an increase, I think, generally in the productivity with the introduction of an additional Crown Court judge and some changes to the way in which Crown Court cases were being processed. So what I'm saying is essentially that the proper and true consequences of the cuts in 2011 are, first of all, equating to a 50% cut in remuneration, and secondly, are consequences which will only be properly understood once we return to the normal levels of Crown Court cases, which we anticipate, certainly from all of the information that we're receiving from a variety of sources, which we anticipate will happen this year.
Okay, thank you. Mr. Wells?
You saw the tables that were published showing your colleagues' pay out of legal aid. Mrs Elise McDermott averaged £800,000 out of legal aid over this last 4 years. What's proposing is consul's fees to be cut by 22,000. Could Mrs McDermott provide a first-rate service for 625,000 a year rather than 800,000 a year?
Well, can I say that first of all, obviously, it's very tempting in a debate like this to personalise the issues. But what I would say in response to that is, first of all, in 2007, the government commissioned a report to determine whether or not the provision of representation in criminal cases could be achieved more cost effectively through the establishment of a public defender's service. The report, which was headed up by Professor Moorhead, concluded in 2007, so that's before any of the recent cuts to legal aid were introduced. He concluded, in fact, that not only was a public defender's service not cheaper than the kind of system that we currently have in Northern Ireland, he in fact concluded that it was considerably more expensive. He concluded that when you take into account, for example, pension requirements, the provision of industrial rights, paid leave, support service, administration, and supporting staff to underpin such a service, that you in fact result in a situation where on any given case you might find that the expenditure is about 50% greater than the expenditure that you would currently have to commit to for the provision of services in the way that we provide them. The second point that I have to make in relation to that is that another government-generated report, the Bain report, also concluded that the way in which the bar provided those services was such as to receive a resounding endorsement from the Bain report as to the system and its operation. So really what I'm saying to you is that the service that is currently in place in Northern Ireland through the operation of independent solicitors in competition with each other and independent counsel in competition with each other is that it provides a much more cost-effective system than might otherwise be provided through the likes of a public defender's service, and it also provides a high quality of representation which you might not otherwise have.
Mr Duffy, would you feel motivated to provide that service for a mere £600,000 a year? Well, could you scrape back?
Well, let me tell you something about the way in which let me tell you something about the way in which council conduct their business. In any case that I'm involved in, my aim is to attempt to provide the best possible service that I can to.
And could you do that for 600,000 a year?
Well, let me just finish. Our concern is not about individual barristers, and of course, I mean, I could say to you, well, look, you know, there are many barristers who earn
Scraping down $250,000 a year.
No, there are many barristers who earn very little and who spend an awfully long time developing and honing their skills in order to survive at the bar. I mean, I myself, the last pupil that I had, found herself in a situation where, because of the pressures on legal funding and because of the pressures on solicitors and the pressures on the system, that she in fact felt that she had to leave Northern Ireland and go and work in a commercial firm in England that doesn't do legal aid work. So I think that it's more important to focus upon the system that is providing those legal services, and to see whether or not the system is working properly, and see whether or not there are potential hazards to that system as a consequence of these recent cuts and indeed the proposed cuts that the legal services, that the Department of Justice is now proposing.
But the public find it very difficult when they look at those tables, because you have to go a long way down that table to get someone who's only getting £250,000 a year. Now, in the real world, a lot of people actually think £250,000 a year is actually quite a good salary, and believe that a solicitor, barrister, QC could actually feel motivated to provide a first-rate gold-plated service for a mere £250,000 a year. So, what I want to do, at what level do solicitors, barristers have a lack of motivation to provide a first-rate service? Is it £200,000, £600,000, or in one case last year, is it £1 million a year? Surely, when you get up in the morning, you could feel motivated for a mere £4,000 a week.
Well, let me put it this way. If, for example, it was decided that we were going to have a public defender system, and this has happened in areas in England, and you decided that you were going to fund that public defender system, and there have been figures published in England and Wales about the level of financial commitment that it would take, for example, to fund a QC or to fund an experienced junior counsel within a public defender system. Whenever you take that into consideration and you think about the degree of administrative support that's required, the degree of additional funding that is necessary in order to provide all of the relevant industrial rights and all of the relevant additional benefits that would be provided to a person working within a public service like that. You actually find that Professor Moorhead was right when he said in 2007 that that kind of an in-house public service cannot compete in terms of value for money with the kind of service that is provided by independent members of the bar. Now, it may well be right to say that in any profession, and this is true of the medical profession, it's true of many other professions, that those who are most experienced, most talented, who have spent 30 years in a particular field, who've developed a certain degree of expertise, will of course find themselves in cases which provide the greatest reward for their abilities. But I might also add that most of the successful counsel that I know operating within the criminal field are working 70 hours plus a week. They're not receiving any additional support. If they find that they are unable to work through illness or for some other reason, they have nobody to fall back on. It is a massive commitment that you have to undertake to commence a career at the bar. My first year at the bar, I think, earned about £4,000. That is not uncommon. People spend 10, 15 years at the bar trying to develop themselves into a situation where they reach the pinnacle of the profession. And indeed, the public have an additional benefit, not only in terms of the level and quality of representation which is provided by those who manage to survive and to achieve the pinnacle of the profession, but that also provides a source of candidates for the Crown Court bench, for the County Court bench, for the High Court, and indeed for the Court of Appeal. So I think it is disingenuous to focus upon the very pinnacle of the profession, whilst at the same time not really taking into consideration the vast benefits that the structure of this profession provides. And indeed, that's not something which the Bar Council are saying. That is something which has been said in 2 government reports. And that is something which we respectfully say underpins our argument that the way in which the bar is structured and the way in which we provide services is the most effective way that it can be done.
You quoted a paper from 2007. Do you accept that the economy has changed dramatically in the intervening 5 or 6 years?
Not only has the economy changed since 2007, but in 2008, standard Crown Court fees were reduced through a process of the introduction of new Crown Court rules. And the bar were told at that time that, that the standard fees had to reduce because of the need for predictability. That was accepted by the bar. We were told that, in fact, there would be some recognition of the fact that we were taking a responsible attitude in terms of the necessity to provide a standardised system for Crown Court fees. That was then further reduced in 2011 by another 50%. So whilst the economy undoubtedly has suffered a number of significant challenges, there's absolutely no doubt that the profession, both solicitors and barristers, have also undertaken and accepted cuts representative of about 60% of their remuneration in the same period. So, and I echo what Mr. Michael Linton has said. The bar is not blind to the need for fiscal responsibility. We perfectly accept that there is a need to ensure not only quality of justice, but value for money in terms of the amounts that are paid for the representation which is provided. And can I say that I suspect that it is beyond contradiction that we have done that since 2008. So in actual fact, if Professor Moorhead were now asked to go back and revisit his analysis from 2007, I suspect that he wouldn't be saying that the cost of these alternative systems is considerably more. I think he would probably say that the cost of these systems is exponentially more. So I accept the point that you make, but I think the bar has properly and responsibly responded and reacted to it.
The last question, Mr.
Yes,
Wells, and then I'm going to take
I spend an awful lot of time in courts for various reasons, and I have to say, I don't see any evidence whatsoever of reluctance on senior or junior counsel or solicitors to take on this work. that none of what was predicted to have happened after the 2011 cuts has come true. There's no evidence of the top names that are in that list. There's still top names in that list. They're not defecting to entirely private work. They are still continuing. In fact, some of them have increased their take-home pay up to, say, up to £1 million as after David Ford's cuts. So therefore, why should you not take a 22% hit, which will still leave you on as double as a brain surgeon's salary? Why should that not happen?
Well, I don't know if that's right, but can I just come back to the point that I made earlier on, that the effects that we had spoken of, the potential impact of these cuts has been significantly masked by this huge put-through of Crown Court cases in the last year, 2013 to 2014. And I mean, if the committee wants to test whether or not our analysis is correct, what you have to do is see what the financial year brings in April of 2015. I mean, we're predicting, very clearly, we've put it in black and white, that the number of Crown Court cases is now reverting to its normal levels. 2013-14 was a wholly exceptional year. That the amount of money expended on Crown Court bills has reduced significantly, notwithstanding the fact that we have done almost 70% more work than we've done in previous years. And next year, in fact, you're already seeing the signs of this at present. Next year, you will find, when the Crown Court cases reduce back to the normal level, and people react and change their productivity accordingly, that you will see very, very substantial deficits and cuts in the amount of remuneration being paid to solicitors and counsel. And that is without the need for any further action in respect of fees. We do accept, I have to say, we've made this clear to representatives of the Department of Justice, that there are better ways to organise the remuneration. There are cases which involve what we've described to them as heavy lifting, which we feel are perhaps at risk of not being undertaken. And this is happening in England, of course, and the committee, I presume, is well aware of the situation that you have in England of a fraud case which is stalled, which had been stayed by a Crown Court judge, reinstated on appeal, but which at the moment is going nowhere because no one in England will do the work, notwithstanding the fact that in England they have retained a system of very high-cost cases and special preparation, and we no longer have that in Northern Ireland. So that is the kind of thing that we are warning of, and that is the kind of thing that will, we respectfully say, come to pass in due course if further cuts are made in relation to the levels of remuneration.
Thank you.
Mr. Chairman, there's just one further point I would make in relation to this, and it's in relation to the issue of the publication of lists of high earners in the legal profession. It's simply this, that since I was appointed as chairman of the Bar Council, I have asked on a number of occasions from the department as to why lawyers, legal aid practitioners are being singled out by being named in lists, whereas other recipients of public funding, such as general practitioners, are not singled out. Now, we know that there are lists published by the Department of Health each year which detail very precisely the earnings of general practitioners in each general practitioner practice in Northern Ireland. But none of those general practitioners are individually identified. They're identified by means of a cipher or a code. And what I would like to know, and what I haven't been given an answer to yet, is why lawyers are not afforded the same degree of privacy protection as are afforded to general practitioners. And maybe it's something that this committee might take up with the department. Now, in relation to the issue of the high earners and the list that your committee member has referred to, one of the key features, I think, that will determine how that is viewed in subsequent years is the fact that in the present year, the number of two counsel certificates in cases has dropped from 56% of Crown Court cases down to 21%. Now, bearing in mind that most of those high earners are QCs, you will find that that particular quite dramatic drop in the number of two counsel cases will feed through and have a significant bearing on the earnings of senior counsel. So that's one thing to take from the changes that are occurring within this Crown Court. The other issue which I raise at this stage is why are counsel and solicitors being singled out for publication when other professional groups within Northern Ireland are not similarly personally identified?
Mr. Chairman, if I may just answer as well in relation to the last question to Mr. Wells. Mr. Wells mentioned one very senior barrister in particular. I'd like the opportunity to outline to the committee the difficult situation of 180 young barristers who, until this summer, I represented chairman of the Young Bar. Last September, the Young Bar Association commissioned a financial survey amongst all of our members. And the results of that survey showed that all members of 5 years qualification and below, the people who have been out working as barristers for 5 years, out of all those members, only 11% earned more than £20,000 in the previous financial year. These are people who have very good GCSE, some of the brightest and best with very good A-level results, very good degree results, who sat a competitive entry exam of nearly 1,000 other law graduates to give our now 20 places at the Institute of Professional Legal Studies, who paid £10,000 in their fees to the Institute of Professional Legal Studies with no student loans available, who then undertook a 6-month pupillage under a senior barrister which was completely unpaid. Now, all of the bar trainees and all the pupils are made acutely aware of the difficulty in undertaking publicly funded work. They are encouraged to undertake pupillages with commercial, chancery, employment practitioners. But so many of our members do turn towards publicly funded work. I think there's a very simple reason for that. So many of our members, probably like so many of the people around this table, have got a social conscience, believe in social justice, and they want to go into the criminal courts and defend that person who's coming up against the might of the police service, which is funded to the tune of £1 billion, the might of forensic science service, the might of the PPS, and be that person who is there to stand and represent that one person who unfortunately finds himself before a criminal court. But increasingly we are finding our members, the brightest and the best, who have understand the concept of social justice, who want to fight for those people, saying, I find it so difficult to stay down this line, I find it so difficult to maintain my practice in the early years. And the concern that we all have and the Bar Council have is not about the fees payable to our members. The concern is this, that the brightest and the best, the most capable, the most able, the most hard-working, who are working the 60, 70 hours a week, are going to say, I don't want to do publicly funded work, I don't want to be a criminal practitioner. And the concern that I believe the members before this committee should have, the concern that society should have is this: if the brightest and best are not going to stand up to the plate and undertake publicly funded work, become criminal defence practitioners, then who will? Do we want a mediocre system, or do we want a justice system that everyone else in the world is jealous of? A colleague from the Southern Bar told me last week that the most efficient criminal justice sector in all of Europe is actually the Russian criminal justice sector. We want the very, very best. Surely that's what we want.
And I will bring other members in, but are there too many barristers?
No. The bar is a competitive environment, but it's one of the strangest competitive environments. Everyone has a master who doesn't get paid for teaching someone for 6 months. Everyone has a close connection of other barristers from a bar family who support them in their early years of practice. The bar does not want to pull up the ladder and say this is only for a select few. The bar opens its doors now to 20 members per year. Say there's work available, and the bar does its very, very best to support those. But in the publicly funded sphere, it seems that the work simply won't be there, or the remuneration won't be there to support those members.
Are there too many QCs?
Only 10% of our members are QCs. Again, that's not perhaps for me to comment, it's perhaps one of the QCs to comment on. Only 10% of our members are absolutely specialists in their area. So it's across the overall number of barristers, it's not too many.
Is it for the taxpayer to keep barristers and QCs in a job?
Certainly not. And that's why we work in a competitive environment. There's absolutely no guarantee of work. No barrister of right has access to work. They're reliant, and this is the competitive system, they're reliant on trying to be better than their competitors, they're better than other members of the bar library to ensure that the solicitors keep coming back to brief them.
Can I just say, just on that issue about QCs, there seems to be a misunderstanding about the impact that experienced counsel have on the criminal justice system. There seems to be a misunderstanding that people who are experienced practitioners operate to some increasing cost to the criminal justice system. The truth of the matter is simply this, that when you have an experienced counsel in a case, the prospects are that he will act in a way which will in fact massively increase the efficiency of the running of trials. He will have the experience to find a way to resolve cases in a way which might not be within the experience of less qualified, less experienced members. And in fact, if one looks at the length of trials, for example, in Northern Ireland, there's a very clear correlation that cases in Northern Ireland are resolved more quickly than they are in England. That counsel in Northern Ireland managed to run trials within a shorter period of time and can resolve trials in a way that doesn't seem to happen in England. And part of that is down to the expertise and experience of senior counsel. I mean, I'll give you an example of the kind of thing that is happening within this system, and just to indicate to you the value of having experienced senior counsel. I was involved in a case earlier on this year involving a young man with a completely clear record, guy in his early 30s, financial advisor, 2 young children, charged with a number of offences of fraud arising out of advice that he had given surrounding a mortgage. He went on trial. Trial lasted 2 weeks. Within the end of the first week of the trial, I'd spoken to my solicitor and had asked for the solicitor to provide bundles of documents so that the jury could have access to the material that the witness was being cross-examined out of. The solicitor contacted me later on that evening to say, look, we can't afford to photocopy 13 bundles. We've run out of money for the funding in this case. I then told him I would pay for the copies myself, but that I couldn't properly represent the defendant in those circumstances without documentation being available. He arrived the next morning with 9 copies. There was a delay to the trial starting. We had to cobble around to try and get additional copies put together for the members of the jury. The judge was very unhappy about the fact that this had occurred, and obviously, as you can appreciate, there is a cost to the running of the courts when there are delays in cases. The next day I needed another 13 bundles. I stood in the bar library myself on my own printer, printed them off, stapled them myself, put them together and had them available for the jury the next day. The judge asked whether I had the bundles ready, and I explained to him that I'd done it myself because the solicitors couldn't afford to do it. Now, when you have experienced counsel in cases, it makes the system run so much better. That man was acquitted of those charges. And he, like many other people who come before the Crown Court, was coming there with no experience of it, with a completely clear record, and somebody who ultimately was vindicated by the system. Now, once you start to remove experienced counsel from cases like that, there's a social cost because the quality of representation goes down. There's also a financial cost because, as the committee is well aware, the cost of imprisoning someone in Northern Ireland per year is somewhere in the region of about £90,000. I mean, if I'm involved in a case and I do a proper job and properly defend a person accused of a serious offence, and as a consequence of that they're acquitted, and then they are spared a wrongful conviction and imprisonment for, say, a period of 5 years. The saving to the public is not just the guarantee of proper access to justice, but there's also a very substantial financial saving as well. So, in short, good counsel and experienced counsel make the system much more efficient, and they also provide an excellent service to the public.
Thank you. Mr. McCartney.
Thank you very much, Chair. Thank you very much for your presentation. I mean, I think that the principle and the need for legal aid is well established, and certainly we would be very supportive of it. In terms of asking the particular questions I'm going to ask, it's around the impact on access to justice and the quality of justice. Now, obviously, cost of justice is obviously an issue, and it has to be discussed as well. The last time the department was here, they told us that they were entering into discussions with both the Bar Council and the Law Society. Could you give us some indication of how those discussions went?
We haven't reached agreement with the Department of Justice because the fundamental point that we were making to the representatives was that they did not yet fully understand the impact of what had gone before, that what has happened in the past is that the Department of Justice has found itself reacting to the different variations in the requirement for legal aid payments, without really understanding what is laying at the heart of it. And what we were saying was, if you in fact allow the full extent of the previous cuts to filter through the system, and in fact that was something which was commented upon in the original Access to Justice review in 2011. The authors of that report said, look, it's going to take quite some time for reductions in council and reductions in fees and the abolition of VHCC, for all of that to really work its way through the system. So really what we were saying to the department is, look, we're quite happy to work with you on the structuring of fees to make sure that cases that require more work are properly remunerated, and that savings, if there are savings to be made in other areas, that those savings can be properly made so that you have a fair, targeted system of legal aid. But what we were asking them to do was to pause, to see what the true effect of what had gone before actually was. I mean, this is, I think that the chairman had described legal aid as, I think the analogy was that it was trying to turn around a tanker. And it's a fairly good analogy, but what is currently happening is that the tanker is turning around, but the tanker is going to continue turning and turning and turning. It is not known just at this moment exactly how far those cuts are going to go. So we were really saying to the department, look, why don't you wait until the end of this financial year, when you can actually properly measure the cost of the provision of criminal legal aid for Crown Court cases. We're quite happy to talk to them about restructuring the way that fees are paid. We'd certainly spoken to them in a very constructive way about the problems that they're facing in England, for example, with lengthy trials and trying to get people to act in those cases. We've spoken to them about some of the inequities contained within the fee structure. We agree with them that there are some issues about the way in which fees are being structured. I'm more than happy to talk to them about that. But on the fundamental issue of budgeting, we simply think that they don't have the information to properly advise the committee, and they don't have the information to properly understand the true impact and the true cost of what they're now proposing. So
your proposal was to postpone this to the end of this financial year?
Yes.
And earlier, in one of the questions, you talked about better ways to remunerate. Did you put any ideas?
Yes, we did. We talked to them about. We do agree that there is some inequity in the way that some cases which resolve, which involve huge numbers of papers, can be reasonably well paid. But some cases which actually require cases to run as a trial for a period of time are not being properly paid. And this is in fact, the problems in Northern Ireland are likely to be even more pronounced than the problems in England, because at least in England they have some mechanisms to accommodate the exceptional case. I mean, if, for example, you had a case like the Haddock trial, which was a multi-defendant supergrass case that lasted 4 months, there is no real facility under the current rules to accommodate that at all. And in England, certainly they have encountered great problems in trying to accommodate very large trials like that. There are no council in England who will attend to those trials, even under the VHCC system that they have there. So we're concerned that some of the more difficult pieces of work are not being properly addressed. At the same time, we recognise that there may be some other areas where there can be savings made. But that is something that certainly we're more than happy to engage positively with the department on.
I mean, the reason why I asked is that the paper presented today, doesn't say that they should be paused. If you like to have the full assessment of impact. Yes. So, would it be possible for you to put to the committee the proposals which you think the department should consider, and whether or not you consider that will save the department money, and how much?
Yes, well, I think the initial estimate that we had that we provided was that on the basis of the figures that we had at the end of June, we thought that without doing anything at all, without introducing any rule changes, the department would see at least a £3 million saving over the next year. The department, I think, were targeting, they were saying that with the new rule changes, they hope to achieve a saving of £3.6 million. We were saying, without any rule changes, you will achieve that. And in fact, we then received the detail of the figures that was contained in the Access to Justice Review document number 2, which was just released to us relatively recently. And when we saw the figures for the 2013-2014 year, we then, in fact, conducted a further evaluation, and it seems to us, in fact, that the savings will far outstrip the 3.6 million the department had targeted, and we think that, in fact, savings could be in the region of about 8 or 9 million. So the Department of Justice are operating upon figures that they have for the year 2013-14. Everybody accepts that that was a wholly exceptional year for a whole variety of reasons, and it's not a proper model upon which to base the potential costing for the next year going forward. So they quite simply just don't have the information. And when we raised this with the Criminal Justice Inspectorate when they came to see us recently. And I have to say the impression that I got was that they recognise the need for a proper understanding of what cases are coming through, what is the demand going to be in the next year, now that all of these other variations have been ironed out, and how can we plan for that? So, we effectively are saying that there will be very, very significant savings already in place and demonstrably in place by the end of this financial year. You will be able to look back at 14-15 and see the true effect of what we've been discussing.
But currently what the department are proposing, have you a rebuttal of them and what you think should replace it?
Yes.
Can we be supplied with
Yes, certainly we can certainly provide something of that nature.
I think you're quite right, Mr. McKernan, to focus on the quality of representation. That's our overriding concern. And if the committee wanted to see what the effects of cuts have been in England, I would urge the committee to consider Sir Bill Jeffrey's report, which was commissioned by the Lord Chancellor, which he published just before the summer. He outlines grave concerns about the quality of representation that defendants are getting in the Crown Court in England and Wales. I think that's something that the committee should read and should really bear in mind when they're considering these proposals.
Is that solely down to reduction in cost, or just?
He links that in to the cuts in legal aid, the constant cuts in legal aid over a period of time in England and Wales, that the correlation that he makes between the quality of advocacy and the reason for it.
And that's people leaving the profession because they're being paid less?
No, simply his observations of seeing counsel and sister advocates in court, and also his observation of having spoken to judges and their view of counsel appearing before them in court.
I think one of the things that is happening is, and this is certainly happening in Northern Ireland, solicitors are under immense financial pressure. I mean, they, like members of the bar, have increased their productivity to try and compensate for that. But a solicitor facing that kind of pressure with a reduction in fees, when he's faced with the prospect of a client in the Crown Court facing a serious charge, he might say, well, look, I'm not going to instruct counsel because if I put one of my own solicitors into that case, okay, they don't have the same experience, they maybe haven't been practising as long, they maybe won't provide the same degree of insight into some of these cases, but I would put a junior solicitor into that case because I can't afford to do anything other than that. Then you might have a defendant in the same trial, and a solicitor might say, well, even though it's going to cost me money to put counsel in the case, I'm going to put counsel in the case. So you have a second defendant who's got an experienced junior counsel. You might have a third defendant then whose family say, well, look, 3 or 4 years ago you would have had a senior counsel in this case, and we want the best for our relatives. So the family then say, well, look, forget about legal aid, we'll fund this and we'll have senior counsel in for you. You can have a case in the Crown Court in Northern Ireland with a relatively junior solicitor for one defendant, an experienced junior counsel for another defendant, and a senior counsel for a third defendant. And then the idea that we might stray into a two-tier system of justice is already here. I mean, if you're somebody like Cliff Richard and you wake up morning and you find that you suddenly find yourself in the Crown Court unexpectedly, he can afford to have whatever quality of representation that he wants. But if you are a potential defendant in Crown Court proceedings in Northern Ireland, and I have to tell you, in the last year I have defended prison officers, I've defended police officers, teachers, grandfathers with clear records. I mean, I have defended people from all walks of life, and a huge number of them have no previous experience of the criminal justice system. So if you think that the people who appear in front of Crown Courts are all criminals, it's just simply not right. And but what happens if you happen to be one of those people? You're a mortgage advisor, or you're a teacher, or you're a prison officer, and you find yourself charged with a serious offence. You come before the court. It is starting to become a little bit of a lottery, because the financial pressure means that you could get any one of a variety of different levels of quality of representation. And it will ultimately reach a stage where people who have the money can afford to pay for it, can afford the best representation. And people who don't have the money, many of whom come before the courts, many of whom are constituents of members of this committee, will find themselves at the mercy of what they can afford. And there's no doubt, I mean, be under no illusions, there is a huge difference in the potential quality of representation available to people. And if you want to make sure that people have a proper level of representation, then that is something that has to be considered very carefully when you're looking at these proposals.
Yeah, just a final, it's more a comment than a question, but when it comes to making decisions, we have to see the alternative as well, because going back to 2011, it became very obvious that the department and the professions were miles apart. But because of the high cost trials was in the middle of it, yes, no one was going to, prevent that changing. Yes. And this went through. Yes. This time there's a better opportunity, but we have to see the alternative rather than
absolutely
the two.
Well, can I just confirm to you that we are in the process of trying to work constructively with the department. Indeed, there are a number of things that we've been able to agree on in terms of how certain fees should be approached. The department agree with us that there is a potential difficulty about some of the more protracted trials. We agree with them that there are savings that could be made in relation to the way that these things are structured, which could then be devoted to targeting areas that really need it. So we have a good relationship with the representatives of the department, but we disagree fundamentally with them as to the full impact of what has gone before.
Okay, thank you.
Mr. McGuinness.
Thank you very much, Chair, and thank you for your presentation. You make a very convincing argument in relation to the fact that the cuts, the 2011 cuts, have not really been seen in their fullest manifestation, and that I suppose arising out of that, you're asking for the department to delay any alteration of that system until such time as we see the true figures. And as a result of that, the department could quite reasonably turn around and say, well, we can't wait, there are budget pressures here at this moment in time, everybody's looking for more money, there isn't enough money to go around all the departments and so forth. But are you saying that you could guarantee that there will in fact be a saving without any further cuts?
Yeah. What I'm
and
saying,
it's really the extent of that
yeah,
saving that you're talking about.
Yeah, what I'm saying is that if anyone looks at that table on the latest access to justice document, yes, which is not compiled by us, this is compiled from figures provided by the Department of Justice, yes, and when you work out the cost of that is the cost of those individual bills, it's very easy to work out. You simply divide the total expenditure by the number of bills being submitted, and then you ally that to the information that we have. And if you want an independent source for this aspect of our analysis, you can go to the judges, you can go to the PPAs, you can speak to members of staff who operate in the courts throughout all the different county court divisions of Northern Ireland. The number of cases coming through this year is down massively down. And when you then, even if, for example, the number of cases went back to the level even went back to the level of 2010 and 2011. And then you work through what the respective costs of bills now in 2014 as compared to 2010-11. You will see that there is an unanswerable case that there will definitely be significant savings. Definitely will be significant savings.
The information from the court service shows that in the final quarter of 2013 and the first quarter of 2014, the second quarter of 2014, there have been an average number of cases being committed from the Magistrates Court to the Crown Court are down by 17%. So the statistics are there, not only the anecdotal evidence from the DPS, the practitioners and the judges. We know they're down. On top of that, as Mr Macklin has outlined, the number of true counsel certificates have fallen from 56% of cases to 21. That will have a knock-on effect. And going further, there were recent changes to the Magistrates Court rules this year, which will reduce remuneration in the Magistrates Court, and as well the provision last year of fixed penalty notices for a lot of Magistrates Court cases will take the department envisage 1,500 cases, and practitioners are saying probably more cases out of the Magistrates Court. So by the end of this financial year, we feel the results will be clear, that the amount of expenditure will be down much more than what it was last year.
And so you're really saying the department's nothing to lose in this?
Absolutely.
Yeah. Just finally, really, I note in your document that the effect of the proposals is a cut of up to 46%. Is that something which the department would confirm, or is that just your estimate?
That's
Well, I think the initial aim of the department was to secure savings of between, I think it was, depending upon the nature of the fee earner, to achieve savings of between, I think it was about 25% and 46%.
Yeah.
Unfortunately, they subsequently then had to accept that their analysis of the 213 case study was in fact flawed, at least in some respects.
Yes.
We suggested to them that it was flawed in additional ways, but they at the very least concede that they got some of their figures wrong on the 213 cases, and they then had to amend their targets to savings of, I think, between 25 and 30%.
Right.
But those proposed savings of 25 and 30% are on top of savings in the last 3 years of 48%. So what you're really talking about being proposed here is a cut from 2010 until 2014-15, some in the region of about 60-70%.
Yeah. Okay, thank you very much.
Mr McGlone?
Yeah, thanks, Chair. Gentlemen, thanks very much for coming before us here today. Could I ask you just, first of all, just by way of information, you referred, Mr Duffy, to a report by Professor Moorhead.
Yes.
Who commissioned that report, and what is the report?
That was commissioned on behalf of, I think it was the Department of Justice in England and Wales.
Right.
And the purpose behind the report was to establish how effective, I think at that stage there were 4 public defenders services operating within England and Wales. And he and his team were being asked to assess their efficiency and to assess their productivity and to assess the question of cost. What he had indicated, it's a very lengthy document, it's about 350 pages, but what he'd indicated was that on the basis of the information available to them, and this is without taking into account the massive cost in setting up a public defender system, forgetting the capital cost involved in that. He estimated on the basis of the cases that the public defender system were then doing in England and Wales that the difference in running costs were between 40 and 90%. So that is that the public defender system was costing between 40 and 90% more than the private sector, effectively. I suspect, although I don't know, that the report was perhaps commissioned with the expectation that the outcome would be somewhat different. But I think it's fairly clear. And that's the only study that I've seen in relation to that. But it seems fairly clear that that when one is looking at efficiencies of systems, the system that we have with independent counsel and independent solicitors, quite apart from providing a local service to constituents and to people in need of legal advice, also provides an exceptionally efficient service. And of course, we're all competing with each other to make sure that the level of service we provide is of the highest quality. I compete with other QCs, and solicitors compete with other solicitors.
Right, thanks for that. Now, to bring you on to, I'll take another year, the figures that have been given to us by the department here, that's for the cost of criminal aid per capita.
Yes.
And they've done a comparison with England and Wales. Well, sorry, the figures here are per capita, this is per annum, £17.23, 17.94, and for Northern Ireland it was 27.72, which is, rough calculation, 60% more. Have you any explanation, or what's your take as to why that should be higher?
There's a number of reasons. First of all, I don't necessarily accept that analysis is a proper analysis.
It's the department's just, you know.
Well, the department have accepted that they've got analysis wrong in the past as well. But what I'll say about that is this. First of all, you take, for example, last year in Northern Ireland. If you were to use last year as a comparison as to the cost of legal aid per capita, you would get a completely flawed analysis because the cost was exceptional that year. If you were to take, for example, 2010-11, you might get a different view of it, and if you were to take 2011-12, you would get a different view of it because of all of these various...
Your argument then that this year, 2012-13, is exceptional.
Well, yes, 13-14 was exceptional, but
This is the year before that.
Yes.
12-13.
But what I'm also saying is this, that first of all, in Northern Ireland we have a much greater reliance upon legal aid than any other parts of the United Kingdom. Most statisticians will tell you that it is not correct to compare, for example, England and Wales with Northern Ireland. I think they suggest that there are some other regions of England and Wales which perhaps compare more directly in terms of the amount of uptake of legal aid. But the other point that I want to make to you is this. In England and Wales, the vast majority of criminal cases go through the Crown Court. In Northern Ireland, we have probably about 40–50% of cases that would find their way into the Crown Court in England and Wales being dealt with in the Magistrates Court in Northern Ireland. So we have a greater efficiency in terms of dealing with cases like that. But what that means is that cases that then find their way into the Crown Court in Northern Ireland tend to have a much greater level of seriousness on average than cases that are being dealt with in England and Wales. It's very difficult to draw a direct comparison, but what I would have to suggest is that I think that if you were to look at those fees over the course of the next financial year, you would probably, and if you were to make a proper assessment allowing for the increased uptake of legal aid in Northern Ireland because of our lower levels of earnings, I think you would probably see very, very favourable figures. The final point I want to just make upon that is there was an article carried in the Daily Mail a couple of weeks ago which highlighted some of the difficulties that are occurring in England about the level and quality of representation. A judge in South Wales had to censor an advocate who appeared in front of him because, as the judge said, he appeared like something out of Harry Potter. This was a man who arrived with all sorts of ribbons and medals on his gown and who behaved in a way which was so unusual to the judge that the judge had to comment upon this man's capability as an advocate. Now, unfortunately, his client got 5 years for careless driving causing death.
What about
But if you want to see Hagrid at Belfast Crown Court, that's just really a kind of a taster of the kind of thing that is happening in England and Wales for the level of fees.
Well, you're all very properly dressed here today. Can I move on
I
to
wouldn't want the
something?
Daily Mail to be my lead witness in any case. I don't know to be honest with you.
Not a good quote then. Can we move on then, because you were taking us into an area that I wanted us to come into. The department has said that the rules and the changes, that's strongly of the opinion the proposals won't lead to diminution of services provided by legal representatives in the Crown Court. Now, you touched on and you introduced a word there, inequity, and the principles of that, and you threaded it through to the quality of representation that's needed, and in particular in some of the cases. Now, I note here that on equality impact, the department's initial equality screening exercise carried out last April indicated that a full equality impact assessment wasn't necessary. Now, I'm looking at some stuff here that tells me that 36% of prisoners in England and Wales were considered to have a disability. And we know well here that a lot of people in prisons have mental health problems.
Yes.
Now, and it says here also research suggested that 20 to 30% of all offenders have learning difficulties, with some 50 to 60% of young offenders having difficulty with speech, language and communication. In your opinion, would it be, or should it have been, a full equality impact assessment of where this is going?
Yeah, I think that's a very good question, and I think that absolutely, yes, that should have been the case, because I would say the majority of people that I represent in the Crown Court would suffer from either some form of mental illness or some form of lack of mental capacity. And in fact, in recent years, there has been a huge number of very, very young defendants coming through the courts. I represented a 14-year-old boy who was charged with attempted murder of his mother, who suffered from Asperger's syndrome, autism. He had very, very serious problems. It was an exceptionally challenging case. But unfortunately, it seems that when people do find themselves in trouble with the criminal justice system, quite often there is this kind of a background either in terms of mental ill health, and indeed there would be a disproportionately large section of people that we would deal with who would fall into that level of disability.
So your views on an EQIA, it should be done?
Absolutely, and in fact I think that it's. I mean, people talk about the potential vulnerabilities of certain sections of society. We do deal disproportionately with people who fall into that category, and you know, it's not just that. It's not just that these people require proper representation. They require experienced representation and skilled representation to compensate for the fact that they find the experience of coming through the criminal justice system even more challenging than the rest of us. So, and I think there's a real concern that people who are already vulnerable will be exposed to even greater risks of injustice in the current experience.
Thanks for that. And then finally, I don't know which you were involved in your meetings with the department, and you mentioned there that there seemed to be some thematic agreeing of proposals or areas of agreement that you had with the department. Could you give us a flavour of those? I don't know who you attended.
Well, we'd agreed with the department that there probably needed to be a restructuring in, for example, the way that refresher fees were paid. We felt that in Northern Ireland, once a trial gets beyond 3 or 4 days, the funding that is available both to solicitors and counsel to properly run the case beyond that it starts to drop off quite significantly. In some of the jurisdictions, they weight the payment of fees so as to not penalise people for contesting cases. And one of the concerns that we had was that some of the way that these fees are structured could lead to significant pressures on defendants ultimately to plead guilty in cases where they should not be pleading guilty, or could lead, for example, to advocates being put under pressure to try and shorten cases in a way which wouldn't necessarily be consistent with their obligations to properly represent their clients. So we were very keen to try and find a way to ensure that didn't happen. And the department also agreed with us, I think, that there are some rules which operate under the current structure which are operated rather unfairly. There are rules about the amount of sitting time that a court has to engage in before certain refreshers are paid. There are rules which discourage preparatory work really being undertaken. So what we were trying to do was to find some agreement with the department to structure cases so that you know, you didn't have this one-size-fits-all approach to cases. If you have a case with many, many pages and huge numbers of witnesses, that some account was taken of that. Equally, if you have a case which maybe doesn't have quite so many pages of disclosure and of depositions or witnesses, you know, that there's some account taken of that as well. But you know, I think it's a system that really needs to be fine-tuned in order to make sure that you don't get these kind of lacunas where people are not really being properly funded to take on some of the most difficult cases.
Okay, thanks very much for that. Right, Chair, thank you.
Mr Lynch?
Good, thank you, Chair, and thanks for the presentation. One of the areas that when we were meeting family law solicitors was the cost of expert witnesses in complex cases.
Yes.
Do you believe this is an area where savings could be made?
Yeah, I mean, it can be, but I mean, we've noticed in the last year that the Legal Services Commission have been very careful about the approval of certain expert witnesses. Now what happens, and this has really come in the last 12 months, if an expert witness is required in a case, in a criminal case, they're generally asking for the opinion of senior counsel or the opinion of counsel instructed in the case as to the necessity for certain experts. Can I just say that you know, there is an area about the cost, but part of the cost of some of the experts, it comes about because there are, for example, medical practitioners in Northern Ireland who will not do medical legal aid work because of the rates. I mean, I've approached some consultant psychiatrists in the past about providing expert reports in criminal cases, and they've simply refused because of the level of the rates. They won't do it. In Northern Ireland, you know, there are some areas of speciality for which there are only a very limited number of people. Like, for example, a consultant neuropsychiatrist. You wanted a consultant neuropsychiatrist in a case, say, for example, a case where somebody had behaved in a particular way because they suffered a head injury or some psychiatric defence or something of that nature. You wanted an expert report like that. There's nobody in Northern Ireland will give you that report. So if you wind up instructing an expert outside of Northern Ireland, say in England, Legal Services Commission would say to you, well, look, why can't you instruct somebody in Northern Ireland? Why do we have to go to the additional expense of bringing somebody across from England or sending you across to England? And quite often the reason for that is that experts in Northern Ireland simply will not do it for the fees that are on offer. And even in England, I mean, you find approaching experts who say, no, I don't do that kind of work, I won't do that kind of work. But you know, there's a fair degree of supervision of the instruction of expert witnesses, and I have to say, counsel and solicitors do approach it with a very responsible attitude, and certainly not in the habit of bringing in expert witnesses unless they're absolutely necessary. There's certainly a great degree of supervision now which is ongoing in relation to that area, so it's to be hoped that there's no unnecessary expenditure in relation to those experts.
Ms McCorry?
Gurmaya Carly, and thanks very much for the presentation. I'm listening to your presentation, and I'm concerned about the impacts that it seems to be having on solicitors' firms. I've heard it described as some of them are hanging on by their fingernails. How much of that would you say is due to delays in the system, like the PPS and things like that, causing undue pressures?
Well, I think what we've seen happening. I mean, I'll give you an example. I was involved in a case where there were.
So conscious that the Law Society would
yes,
for solicitors as well. So,
well, I think the pressures. I mean, the pressures on solicitors, I think, are being brought about in two ways. First of all, I think because of the reduced rates, because of the loss of certain areas of work, such as all of these diversions, youth diversions, and diversions for certain types of offence that might ordinarily find their way in the Magistrates' Court, their margins are being cut. They're still having to maintain their offices and to maintain their staff, but they're having to find ways to do their work with less expenditure. One of the ways that they can achieve that is simply by not using counsel in cases, and that is now quite widespread. I think that the result of that then is that solicitors obviously are trying to to do their best to operate within this economic environment. But ultimately, it must mean that there's a compromise in relation to the degree of experience that can be directed to a particular case. Can I also say that there currently are very significant delays in payment within the Legal Services Commission. They previously had indicated that they would have payments processed within a period of 6 weeks. That's now extended to, I think, a period of 12 weeks, which effectively has taken 2 months of income out of the hands of solicitors and counsel. And certainly, I know that's causing a huge amount of difficulty at the moment. But the pressures really are down to the levels of funding. And even though solicitors have, as I said, increased their productivity by about 60 or 70%, like the rest of us, that is simply only masking the problem for the time being. And I suspect that the problems are going to get worse. And I would suspect that there will be layoffs within solicitors' offices within the next period of time.
Yeah. The concern that I was thinking about was that under such pressures that might emerge for various reasons, that in cases where counsel should be instructed, the solicitors might decide to do it, and it might end up in people being convicted, or people ending up with prison records, and because of people trying to survive. Would you think that might be an outcome?
I think there's a general point there which was highlighted by Mr. McGlone earlier, which is simply this, that there is the trend to try and lower the qualification of representation as a means of saving costs. Okay? And the justification for it is that in terms of certificates for two counsel, for instance, it must be a high threshold in terms of the seriousness of the offence and the potential sentence before a certificate for two counsel would be granted, or perhaps the complexity of the factual matrix which makes up the charge. But an interesting point that he's raised, which I think is also something that has to be taken into account, which probably isn't taken into account at present, is the vulnerability of the defendant. Let's say the defendant is a person with learning difficulties or some minor psychiatric issue. Is that not the type of case that should merit the most experienced and skillful advocates representing them when they face criminal charges? It would appear under the system that is in place at present, in fact under these new proposals, that the vulnerability of the defendant, the needs of the defendant are being ignored, and that the criteria that are being used in relation to whether senior counsel should be instructed do not take into account the particular vulnerabilities of the defendant. And it's an issue, I think, that this committee should seriously consider.
Yeah, ultimately, the impacts on access to justice for people who are most vulnerable.
Yes, it affects on. It must be a matter of common sense that those defendants who have difficulties in terms of understanding, or by means of personality disorder, by means of learning difficulties, those are the particular individuals that need the most careful handling and need the most skillful and experienced advocates to represent them.
Okay. Can I just ask you something too? It was raised earlier about individual counsel who attract very high remuneration over a period. Would those people be connected to a firm, or is the suggestion that money goes to one person? I mean, what I'm saying is there a percentage of that which goes to overheads and all of that?
Can I mean, just on that point, in England and Wales, just to give you an example, in England and Wales, Public Defenders Service have advertised for QCs, and they will pay a QC £125,000. That's the rate that they pay them. But then they have to pension them, which is another £30,000. Then they have to also then provide them with all of the materials necessary for them to perform their job. Then they also have to provide them with administrative support. Then they also have to provide them with the environment within which to do their work. And at the end of the day, what you have then, for an outlay of about, say, £200,000, is someone who is paid to work 40 hours a week, has paid leave, paternity rights, industrial rights, can obtain redundancy if they're no longer required, and so on and so forth. I mean, the cost of that is phenomenal. So whenever people talk about the kind of figures that are being bandied about, that includes, quite often these figures include VAT, and they include all of those other expenses which would ordinarily be laid at the door of the public in a publicly funded system. And they also, might I say, don't take account of the fact that anybody who's reached that stage of that career will normally have spent many years earning substantially less than the minimum wage, substantially less than the average wage, and it's only by perseverance that they reach that stage. I mean, at the minute, I think the solicitors can maybe indicate this. At the minute, within the solicitors' profession, there is, in each year, there are 30 or 40 places not taken up for training for solicitors. Within the bar, we have exceptionally talented, very, very able people who are walking out the door because they simply cannot make it. I had come across a barrister who'd been at the bar for about 4 years, exceptionally talented, who had a twin who was a doctor. And while the twin was off earning £35,000 as a junior doctor, with this career path in front of them, with all the structures and security that provides, this barrister was in despair, simply because of the challenges of trying to persevere on this career and the difficulties that she faced. And then, she left and she went elsewhere. She left the profession. So none of that is factored into to what is to these base figures. And you also have to remember that I've been involved in very many cases which, because of the experience that I have, I've been able to resolve. I have saved weeks and weeks or months of court time, and quite often have been able to avoid the necessity for elongated proceedings, or indeed have saved people from the prospect of a miscarriage which could inflict even greater cost to the public service. So all of that has to be taken into account. But when you weigh the costs up and you look at the costs of the public defender service, this is presumably why the government haven't commissioned any further reports since 2007 about this issue.
Mr. Elliott.
Chair, thank you very much. Thanks for the presentation. Just one very quick question from me. There are a number of items in our briefing paper that the department were suggesting obviously could or needed to be resolved. I'm just looking from here now. You did deal, I think Mr Duffy dealt with the issue around the number of papers, and some more complex cases don't have the high number of papers.
Yes.
But still are much more costly to resolve. But some of the other issues, I'm just wondering how acceptable you are of those. For example, solicitors' guilty plea 1 and 2 fees will be removed and replaced by a single guilty plea fee. I'm just trying to tie up, how close you are on some of these issues, whereas we do appreciate there's going to be quite a wide version in some of them, but in some of the others, is there any mechanism of getting closer?
Well, I don't think that the current structure actually really reflects the needs of the system. I mean, for example, the department are really talking about one standard fee for a guilty plea with maybe some kind of an enhancement if it is what would have been called an OGP2. That, I have to say, maybe is coming from the perception that a guilty plea 2 really is just a guilty plea 1 which has been extended. Whenever cases come before the court and a person pleads not guilty and then later pleads guilty, that is effectively a trial that has been averted, not a guilty plea 1 which has been extended. There is quite often a huge amount of work that goes into resolving cases, and I think the structure that is being proposed by the department doesn't necessarily reflect that. But I think the area where we have the greatest concern, I suppose, is in areas of cases that do have to proceed as a trial, where there is this disincentive the longer the trial proceeds. I think the department would probably accept, even on the department's figures, even on the department's analysis of the situation in England and Wales, once a trial goes past 3 days or 4 days, it is much better remunerated in England and Wales than it is here. That's even on their assessment. So we're not. I do agree that there should be some form of a GP1, GP2 trial fee structure, but I think that it should be tailored in such a way as to reflect the size of the case and the complexity of the case.
So are you saying, just for clarification, Chair, are you saying that the proposal in that respect of removing the guilty plea 1 and 2, that would have a detrimental effect on the legal system?
Yes, it would.
Or on the judicial, on the justice
It would,
system?
because I mean, what would happen then is that you would have pressure then being brought to bear on representatives. In that, if this is effectively one composite fee and you're involved in trying to say it's a murder case, and your client pleads not guilty on day 1, and then you spend months and months and months preparing the case, working through the case, and eventually you're able to resolve that case into, say, a manslaughter plea, that is something which is probably not really reflected in a one-size-fits-all GP1 fee with add-ons for preparation. It really isn't. What you effectively have there is a trial that has been averted through the hard work of counsel and the solicitor. You don't want to disincentivise the resolving of cases. And I think the payment of a single fee with maybe some additional room for preparation is probably something which will have an impact upon the way that representation is delivered, and could well lead to undue pressures on people to plead guilty when they shouldn't be pleading guilty.
Thank you, Chair.
Okay. No other members? Can I thank you all very much for coming to the committee? Much appreciated. Okay, members, we'll go straight to the next one, and the Law Society are going to come before us now, so if they can please do so, that'd be great. It's pages 20 through to 45 of your table pack has the information.
Very young barrister, doing like a young doctor. That's right.
I do think the effect will be developed not now, but that's how it is.
Okay, members, can I welcome Alan Hunter, Chief Executive, Pierce McDermott, Arlene Elliott, and Peter O'Brien, all from the Law Society, and these are all very welcome to the committee. And I'm going to hand over to yourselves to give us a briefing, and then members will have, I'm sure, some questions.
Thank you, Chairman, for your introduction and for inviting us along this afternoon. Can I firstly say that I fully support the comments that have already been made by Jerry McAlinden, Gavin Duffy and Michael Ford in respect of the Department's proposals to implement a second round of cuts to the defence services of the criminal justice system. I'm trying to assess the cuts to a public service task isn't simple. The criminal justice system, how do you actually assess when financial reductions have undermined the delivery of justice? In essence, what is the canary in the mine? Some examples may be if you have increased levels of miscarriages of justice, or you would have possibly an unchallenged prosecution leading to declining standards, limited availability of representatives to carry out legally aided work, or a system where only the wealthy can afford to fund an adequate defence. We have it wrong when it's too late, and putting it right is not possible or infinitely more expensive. It's confidence in the system, which is essential to the operation of law and order. Despite our troubled past, people believe, with good reason, that courts will impartially and fearlessly interpret and apply the law regardless of public or political pressure. This remains the case. Considering how the proposed 27% cut may impact on confidence, I make two short observations which have already been made. The budget to the criminal legal aid was cut by 54% approximately 3 years ago, and those cuts have not yet washed through the system, and they will not do so until 2015-2016. The effect of these cuts is presently unknown. It's not clear how the Department assess the impact of those cuts. It would appear that the very existence of a bar library and the network of solicitors is sufficient reason for the Department to conclude that good justice is delivered to the community. Is this true? The anticipated report by the Criminal Justice Inspector may shed some light, and we welcome the opportunity to respond to those comments before the committee in due course. The Department's methodology is to compare and contrast fees in this jurisdiction with that of England and Wales. However, the stringent cuts implemented in England and Wales have revealed significant cracks in their system. It is not an example to which we should aspire. I believe your constituents and our clients deserve better. Often there's a sense that criminals are an undeserving underclass of people who receive benefits and give little to society. Any one of us, though, can find ourselves on the wrong side of the law. The adolescent boy who climbs into a car with neither experience nor wit, causing death. Wife who accepts her husband's penalty points. Young student who has a fight outside a bar, causing a serious injury. We are still a close-knit community, and we still have what is known as the family solicitor, a person who deals with a multitude of issues that come up in a person's life from cradle to grave. People place value on that, place value in obtaining advice and representation from someone who's trustworthy and has their interests at heart, and that's particularly so in a crisis. The majority of people who find themselves in the criminal justice system have troubled childhoods, poor education, mental health problems and addiction issues. We have the highest rate of mental health problems in the British Isles. No doubt your constituency work provides an insight to the challenges faced by many people in our community. The role of the solicitor is a holistic one. We not only consider, analyse and where relevant challenge evidence, but we attempt to turn the crises of criminal proceedings into an opportunity to change the direction of a person's life for the better. Doing so is not easy, but if the work is not profitable, something has to give. Solicitors also live in the real world. We are business people who have sustained the pressures of the recession like many others. Hard decisions have had to be made. We are more than aware of the demand to squeeze the public purse. All of that said, the Legal Aid Fund is a soft target. When the budget was set about 8 years ago, it was estimated in this year that the fund would be £75 million. There was no rationale as to how demand would reduce. The committee is more than aware of forecasting problems and the increase in costs of administration. And the second Access to Justice review may evidence an approach in relation to the legal aid issue, but the emphasis no doubt will be on cuts and not on quality. I'm passionate that we have a system which delivers sound, measured justice, of which we can all be proud. Taking the scythe once again to defence services can only be detrimental. Perhaps, Chairman, if I could touch on the question that was raised by Ms McCorley in relation to what cuts mean to a solicitor's practice. I suppose you're by and large entering into a world of generalities, because solicitors' firms by and large are mixed, and there's a spread of them across the province. But like any business, if there's cuts that are implemented, the effect of those cuts will differ depending on, I suppose, the level or the amount of work that may be done by the respective firms. I suppose as a matter of common sense, if there are cuts brought to a particular area, the solicitor or the firm has to look at the various options to meet those cuts. The first question that would present to any business person is whether they can afford to continue to do that work. I suspect that probably the more rural practitioner is more likely to be faced with that type of option, because the rural practitioner does a smaller volume of that type of work. Another option for a solicitor's firm is to basically cherry pick, to only do certain types of work, and that would appear to be the case that has occurred certainly in England and Wales. Another option which the department refers to is to change the business model, as they call it. And, I suppose my comment on that is that it's very easy to say, small businesses should change their business model. But in reality, what does that mean? In reality, it essentially means for the solicitor to decide, do they basically only take on private payers in respect of this type of work? Or do they really only employ more inexperienced solicitors? Those are, examples of a couple of options that may present to any business person. The other, and I suspect the recourse that most solicitors have, is to essentially look at cuts. And in any business, you look at your fixed overheads, rates, electricity, heating, all of those costs have not gone down, and there's nothing that anybody can do about them. The only element that you can look to make savings within a business is people. So, there's been tough decisions made by many people over the last number of years. Do I keep somebody on? Do I have to look about making people redundant? Do I cut hours? Do I cut salaries? And those are extremely difficult questions, particularly, I suppose, in small businesses, which by and large operate on the ethos of loyalty. Most of us have employees that have worked in a business and worked for very long hours for many years, and it's very difficult to deal with, I suppose, recessionary issues. So, all in all, there's no simple answers to any of these questions, but as I've already said, simply taking a side once again to defence services, I think can only have an impact on quality.
All right, thank you very much. In terms of the assignment of counsel, that was brought up previously by the Bar Council, that solicitors wouldn't then assign counsel. Is that the case?
Well, I suppose it depends if there's what the nature of the issue is, but by and large, I don't accept that solicitors don't assign counsel to make savings. The fees that are set are simply set, and the issue really is basically for, as I said, most practitioners, whether overall they can achieve sufficient fee to make it possible for them to do the work and do it in a manner which delivers a service to their client.
So the proposition that certainly I took that was being inferred was, we make a reduction in fees for barristers, for example, and then the brightest minds, the people that are most capable, won't do the work, and solicitors won't go to them to do the work because they're too expensive.
Well, if it's publicly funded, you basically have to look. If it's publicly funded, the fees are what they are, and if you don't have a pool of barristers that you can utilise, well, yes, you're going to have to think about how you can provide quality representation to your particular client. But at this moment in time, it is possible to get counsel to do work on the fees that are set. As yet, there have been some frayings at the system, if I can put it like that, in certain areas where the remuneration hasn't been sufficient for you to be able to get representation, such as the sentencing fees, which I think is referred to in the papers you will have seen, and was the subject of an appeal which came to the Supreme Court. So I would imagine that if there are further cuts, that you will see additional stresses of that nature.
And what does that mean in real terms? That's very nice language. I like that. But if we can get it down to the bottom line, if we reduce these fees, do we get bad barristers? Is that ultimately what the inference certainly I took out of it was? The best minds won't do the work, so therefore solicitors won't be able to get them, and actually solicitors won't use them because they'll have to cut their own cloth, and therefore you'll go for bad barristers, and people won't get a proper trial, or they won't get the best representation. They'll end up going to jail. That was certainly the message that I was taking from the previous people, that's what solicitors would allow to happen to their client.
Well, I wouldn't say solicitors would allow it to happen. I mean, it's basically a market economy, if you like, and if people if people do not do this type of work at those rates, well, that's it. They won't do it. So will that happen in the future? I don't know. I doubt any of us know. But the bar certainly wish to ensure that there is quality representation within, I suppose, their ranks, and that is very important, and that similarly would be a concern that we would share, that obviously if you keep on cutting and cutting and cutting, either nobody will do it or it will be done very poorly, and that surely is not something any of us around this table would want.
Well, obviously, if you had a publicly funded public defender system, you'd be able to quality assess the quality of those that are working in that regime. Obviously, we don't. It's independent, and now I'm asking myself the question: how much of a variance is there between good barristers and bad barristers? Because the picture has been painted that this will be so bad that the previous speaker indicated that this could be very damaging.
Well,
now, what kind of quality assurance is there whenever people are obviously getting the certificates, they're getting the letters after their name to be barristers? It sounds like I should start getting very concerned about the standards that are being applied to people that actually get qualified to deal with these type of things. Is that something we should be worried about?
Well, there's 2 points. The bar have already made many points in relation to the cost of a public defence service, and I don't intend to repeat them. I'm sure the points have been understood. The second issue in relation to public defence service is essentially one of confidence, and as I've said in my, I suppose, opening comments, it is confidence which has to be protected by all of us. So if I could take the example, for instance, say any one of your children, say for example your daughter is in university and she's an innocent girl and an innocent abroad, if you like, and she rents a house with 4 others, and as time passes the police raid it and there's a cannabis factory in the roof, and your daughter along with 4 others is charged with possession with intent to supply, an extremely serious charge. My question is this: would you be happy taking your daughter to a public defender service to get representation? And if you say you would be happy with that, I don't believe you, because I think most people here would want to take their daughter to probably their family solicitor, because they would trust that that solicitor understands you, understands where you're coming from, and would have some appreciation of your daughter, and would actually care about how this problem is dealt with.
I understand the point you're making. The question that I was asking really is how bad are bad barristers? And I would go to my local solicitor if that was to happen. I would trust my solicitor to then get the right counsel. I would never have probably ever met the barrister that the solicitor would even say to me, Paul, this is the best barrister that should deal with it. How would I know? I would just have to accept the word of my solicitor, and there's that relationship that you trust them to do the right thing by you. But you still would have, at least I would make an assumption, if you're a barrister, what is the variance in standard between the good and the bad? Because the picture that's being painted is one that would cause me concern.
Can I come in there, Mr. Chairman, just on that? Barristers and solicitors, but like every walk of life, there's good MLAs and bad MLAs, as I'm sure you appreciate.
We all get paid to see you.
I'm making no expression about anyone at this table at all.
Give us the evidence. Name them. Are they in this committee? Are these the best MLAs?
Today they certainly are. But the issue I think is this: is that if you continue to cut back at the funding of Crown Court services, if you continue to cut back the funding put in by the justice system into defence services, what you'll end up with is a pressure upon that system. There's only so much work you can put into a certain case, and solicitors as business people have to allocate a certain amount of time, energy and effort into cases. If you cut back the profitability and the amount of money spent in a system, a solicitor will inevitably say, as will a barrister, I can't afford to put as much time into that. Now, everyone will do their utmost and do their best to protect their clients' interests. But in the real world, those pressures, the cutting of the fees, the cutting of the amount going into that case will mean that with the best will in the world, you just cannot give the best amount of time for that. Which means that the quality of the service, the bits that need to be done, going out to the location, going out to the site inspection, going to see the client once a week in prison, going to get forensic expert, all of that will be reduced. Now, subliminally almost, because it's not something that solicitors will do automatically, but it will happen over a period of time because you just cannot afford to spend the time in that. Second point, I think, which is the point you're making, the first point is about whether or not solicitors will use barristers in the future, is that, yes, there are good barristers out there. Most barristers are good barristers. Most are able to do the cases at the present time. But what the bar is saying is that the best barristers will leave because there's no money in that game anymore. That's effectively what they're saying. And that may well happen. But the solicitor will certainly do their utmost to ensure that the client gets the best possible representation, whether it be a barrister, whether it be a solicitor advocate, or whether it be the solicitor himself within the Crown Court. But the pressure of cuts will always mean that the pressure on that individual case could be such that there'll be slippage within the case, and that may lead to some form of deficit in the justice system.
Okay, I'll bring in members. I don't know if this is a good MLA or a bad one, but Mr. McGuinness.
Oh, a very good one.
A good barrister or a bad barrister?
Oh, dear. First of all, I want to apologise because I'm going to have to leave soon, and it's just a present appointment. But you present a situation where, in fact, I detect that solicitors' firms right across Northern Ireland are under pressure. Now, I think I'd make a differentiation because there are some very big firms that can cope with the pressures better than smaller firms, which are one or two solicitors. Is that a correct description of the situation? Would you say that?
Yes, I think it's fair to say that, and I go back to the question that the chairman asked the bar at the very start about, 2011 you came from here and you said, this is awful, these cuts will be a disaster.
Yes.
And they have been a disaster, there's no question about that.
Yes.
They haven't worked their way through the system totally yet, but they are a disaster. And they're invisible cuts, they're invisible losses to solicitors' firms. Solicitors have not taken on new staff, solicitors have let old staff go, solicitors have reduced the staff within their offices. And these invisible, just because the door's open doesn't mean that firm is operating at the same level as it was 4 years ago. And the situation is that there are a large number of firms out there at the present time who are really, really struggling, really struggling. And further cuts, as proposed by DOJ, will lead to those firms eventually having to close their doors.
Yes. And we have a system of solicitors' firms right across the north, that small family firms really, that service relatively small communities. Is that really the pattern?
Absolutely, yes.
And so they will feel the pressure more than larger firms in Northern Ireland, or similar firms in Britain, for example.
Well, I suppose they may feel the pressure in different ways. If they do smaller volume of criminal work, anyhow, it's, then the difference in the cuts you know, obviously have a different impact within that practice. But there's other pressures that I suppose all firms across the board feel, which is just outside of the cuts.
Yes.
It's the overall recessionary cuts or reductions, if you like, as well.
Yes, so it's a combination
of
the recessionary pressures as well as the cuts in legal aid.
It's hard to be absolutely definitive in relation to what element of reduction puts practice in peril, if you like, but you know, you have to look at the cuts within an environment and how that impacts across the board.
So your basic argument is, look, it's premature to bring in further cuts. If you do bring in further cuts now, we haven't seen the final position. The tanker hasn't really turned yet. It's still in the process of turning. And therefore you should desist from any further cuts at this point in time. Would that be the argument?
That's very elegantly put, and that shows why you're both a good MLA and a good barrister. that defines exactly what we're saying. We're saying probably going to slip a little bit further than that, and that we're not saying just defer this. What we're saying is that this can't happen, because if this happens, this will have a major impact upon solicitors' firms and upon the quality of justice offered in this jurisdiction. But you've summarised very helpfully how we see the situation at the present time.
Okay, thank you very much.
Courtney?
Thank you very much. And I think
I'll finish when I'm winning.
Yeah, I rest my case. I mean, I think Alban's last point is the critical point, and I sort of said the same to the bar. And what we need, and I think you maybe have spelt it out, but see, we need a clear picture of what you are proposing. I think we've come close to that in this particular instance, because I refer back to the 2011. It was two opposite positions, and then the decision was made down the middle because of the high cost. This time, that whatever we do, we need to be in a position we can say, well, here's the counter proposal. We might agree with that one, not with that one, or a combination. And I think we're getting towards that. The bar have asked for, you know, like the end of this financial year to assess it. You're saying it's premature, and that's the type of clarity we like to hear, because the committee has asked the inspector to do a bit of work on this, and in fairness to the inspector, the reports are always very good, you know, in our aspects, but one of the things that they'll be looking for is evidence, you know, so the support, when you're saying that there's solicitors firms losing staff, and I know, you know, from personal experience in Derry that they are, we need to have a trail that you can say, you know, here's why, because last year we earned this amount of money, this year we didn't, so therefore the net impact is that we laid off staff as a result of it. So it's that type of clarity that we need, and I think it's to be welcomed. Again, in your discussions with the department, what would your assessment be of where they're at in terms of your counter proposals?
Well, our discussions have basically finished at the present time. There hasn't been any ongoing discussions since before the summer, when the DOJ came before yourselves. So at the present time, unless there's some impetus coming from a third party, we don't believe there's going to be any further discussion with the department. Just on the point you make, though, about evidence-based, you'll appreciate that we're all private practices. The Law Society is funded by those private practices, but the Law Society is not a government agency. They don't have the facility, they don't have the finance, they don't have the structure to get the evidence that you're talking about. That is the purpose of a regulatory impact assessment. And what we say in this case is that the DOJ has failed completely in its duty to do any regulatory impact assessment, how this will affect small and medium-sized enterprises such as solicitors' firms. And that's one of the failings in this report, that evidence can be gathered by the DOJ, by the government, because it's not up to us to do that. So it's too hard for us to do that. We can't fund it for as much as anything else. So we really say it's over to them to do that impact assessment. What we can say, as individuals who work within cities and towns and work with other individuals, is that we know that there are redundancies out there. We know that people are losing their jobs. We know their jobs not being replaced. We know that in the Institute, 45 places have not been taken up this year for young apprentices coming through. And we know that there's a major cutback to solicitors' firms. That's anecdotal in one sense, but it's happening. But we're not in a position to make the detailed forensic evidential basis that you're seeking. But what we can say is anecdotally, it has a major impact already.
Yeah. And in terms of 45 not taken, what you think that's down to, they don't no longer see it as a viable profession, or
no?
I
think it's entirely down to the situation whereby solicitors cannot afford to take on apprentices, because a solicitor has to pay an apprentice and they can't afford to take them on.
Okay, thank you.
Okay.
I think, Mr. McCarthy, as well, we would say that for preparing for today, we looked at a piece of new information which came from a European study, which interestingly indicates, yes, that Northern Ireland, the spend is higher than the rest of England and the rest of the UK. And the average, when they looked at the cost of legal aid, prosecution, and the court service, shows that there's an extra spend of, I think it's €50 a head in Northern Ireland. But when they break that down, they show that in fact the percentage increase that's attributable to legal aid is in fact only 26%, and in fact the increased spend is in respect of the prosecution service and the court service. And what we say really is that, you know, the society, the lawyers who provide legal aid services have been hit with a 54%. We said initially the consultation in respect of the 2011 fees indicated that there were going to be a 25% cut in standard legal aid fees. We said it was 54%. The figures that were referred to earlier by Mr Duffy that appear from the government's, the department's access to justice review show in fact that there is a 48% reduction per Crown Court case. And that's, we say, without the cuts having been fully filtered through, so that our initial suggestion that it was going to be 54, we think that is what will actually happen. So we say that we have, that the lawyers have been asked to bear, in a sense, a disproportionate amount, and that in fact what one needs to do is look at the system, and that in fact it's looking across the system and not just focusing on the legal aid issues. And I think that the committee do seem to be aware of that, and we particularly welcome the involvement of Sagini as a sort of outside arbiter who may be able to assist in dealing with that. One area, for example, would be in relation to, and I'm sure we may hear about the contrast between England and Wales, but and why does it cost more for a case here than it does in England and Wales? One of the reasons is certainly an approach to disclosure of evidence. We certainly are led to believe that in England and Wales evidence is disclosed quite easily by the prosecution service. In Northern Ireland, that will require attempt after attempt after attempt. I'm sure Mr McDermott, as a practitioner, will be able to elaborate further on that, much more than it would in England and Wales. The whole cost, well, I think Mr Duffy would indicate that the trial itself may, on occasions, be speedier. The length of time that it takes to get from the start of the trial to the actual trial is actually much significantly longer here, and we say that's because of a number of problems that there are in the system, which we're not responsible for as the lawyers in the system.
In terms of disclosure, is it still a big issue, the lack of disclosure?
Unfortunately, yeah, it's still a difficulty. You still go down to Crown Court and see on a daily basis what are called Section 8 applications for disclosure, which have to be brought, and very often they resolve themselves. The PPS do supply the information, but you have to get to the point where you've written to them, you have to apply to the court, the judge has to come along and wrap them with the knuckles and say, why don't you give the disclosure? To adjourn for a week, they give you disclosure and the application is withdrawn, but that process still has to take place.
Yeah. That's an added cost.
Well, any delay in the case, and we've been accused in the past of being the authors of delay in the criminal justice process. We have no interest in delaying the criminal justice process. We don't get paid till the end. There's no benefit in us delaying the system whatsoever. We're keen to get cases on as quick as anybody. The delay that needs to be looked at is the situation whereby the police investigation, the file going to the PPS making a decision, and then getting the matter through to the Crown Court trial. There are delays in the system which are no fault of ours, and a delay leads to increased cost because of the length of time it takes to get a case to court.
Yeah. And in terms of impact, is the impact greater on the laws, like solicitors, than it is on the barristers?
Honest answer, yes, because we carry overheads, because we have offices, we have heat, light, rates, insurance, we employ staff. We do, apart from the case Mr Duffy talked about, all the photocopying, we do all of the background work in relation to that, and we have the major overheads, which means that a higher cut to our side of the profession than the bar has a major impact upon solicitors, more so than having the bar, we say, because we have the overheads effectively.
And I asked this question in 2011. would you be in contact with the bar in terms of joint presentation, or making sure that what one asks doesn't undermine what the others seeking?
Yes, we have meetings, regular meetings with the bar to make sure that, well, we've fairly joint interests, so we have meetings to make sure that we are in a situation whereby those joint interests can be put forward to the Department of Justice in a reasonable manner.
Okay, thank you very much.
And since Mr McCartney were on the comparisons within England and Wales, in England and Wales in 2001 the amount of firms doing criminal work was about 4,000, and in 2016 it's now 1,600. And there's a concern that over the next while there's going to be a reduction of those number of firms that do criminal work down to 525 firms. Whether that comes to pass, I don't know. But I go back to the point that England and Wales is not the standard bearer of criminal justice.
But in terms of the committee and in terms of the inspector, that sort of audit trail has to be clearly linked to the reduction in the civil aid or the legal aid budget. So therefore it's easier for it might be a case when you say there's a reduction in solicitors' firms in England and Wales, but it's directly related to the fact that legal aid has been severely cut as well. So that's the type of evidence which I think the inspector would want to present to us, so as we can absorb it then that way.
I mean, I think our position is that these cuts are inappropriate in the first place, and secondly, the timing is completely wrong. There were 54% cuts, as you know, in 2011, and the Law Society at that time indicated that there would be a significant impact on the profession, and I can tell you there has been a significant impact on the profession. When I go along to admission ceremonies every year, one of the saddest and hardest things is the group of apprentices standing in the corner who have just qualified as solicitors but who cannot find jobs, who are working in all sorts of areas, looking every day to see if they can get a vacancy. I'm horrified from time to time to hear of the salaries of 3 to 4 year post-qualified solicitors that could be maybe 17,000 a year. After 3 or 4 years working, still carrying their student loan, trying to get their life in order and trying to buy accommodation or find accommodation and so on. And some of them out of that are paying heavy loans and heavy overheads. On top of that, then, looking at the firms themselves, there's been a great change in the dynamic of firms. There's been a lot of the younger members of the profession who have been laid off. Some of them have left the jurisdiction, some of them have gone into other types of work, been fortunate waiting to come back into the profession. But the firms themselves have changed their dynamic, and the numbers have changed, and one of the things I have noticed is the number of firms registered to do legal aid work is certainly decreasing. I can't give you the percentage, but that certainly is the case. So what we're saying is that these cuts have not washed through. The impact is not yet seen and is not yet known. We don't know what the impact on the client is going to be. But the solicitor is the frontline service deliverer for that person in the community who finds themselves in distress, finds themselves in difficulty, sometimes have no one else to turn to, sometimes are afraid to admit that they can't read or write, and they go along to their solicitor for help, and they get that holistic professional service that deals with everything, that deals with every aspect, right through from the social worker, right through to the PSNI, right through to the court proceedings, deals with all of that in a holistic way. And the importance of that for I think the social economy is not to be underestimated. So what we say is that until these cuts wash through the system, it will be very, very difficult to assess what further impact there will be, but certainly there's been a significant impact to date.
Thank you very much.
Mr. Elliott.
Sure, thank you. Thanks for the presentation. I hear what you say there, Alan, but you'll appreciate there wouldn't be a great lot of sympathy out in the wider public for that argument, just where there mightn't be for people like ourselves. In public life, the reality of it is, though, how do you actually make a fair system? I think that's the real argument. How do you ensure that people who are in difficulty actually gets reasonable representation? Just a question as follow-up to, I think it was maybe Mr. McCartney's question around, and it was answered to some degree the difference between the cuts that these, or the difference that these cuts would make to your profession and to the bar, where is the real difference there? I know you're saying, or somebody said, do you do most of the work behind the scenes? But I'm assuming a lot of it is related to the cost of the legal fee itself for the representation of whether that's a solicitor or a barrister. So where is the real difference there? Who will be affected most? Is it your profession or is it the bar?
Could I maybe just deal with the first part of the question, and then I'm sure Mr. McDermott or Ms. Elliott will deal with the other part. I hear what you're saying about public perception, but this is the justice system that we're talking about, and all of us involved in the justice system, in organising the justice system, and so on, have a responsibility to ensure that the justice system can be upheld, and that's something that this community can be proud of. So it may not be terribly popular with everyone, but it's certainly popular with people and parents who find their children in difficulty or who find themselves in need of the system. So I'll just make that slight distinction. Second thing I want to say is that I also agree with what you're saying, and what the Law Society has been saying consistently for the past 12 months now, is that what is actually required is to review the system itself to see where the efficiencies in the system can be made. And the department's first port of call in 2011 was to come to lawyers' fees, deal with that. 2014, coming back to lawyers' fees, we would say that in the interim, what the Department of Justice should have been doing, and what they should be doing now, is to look to see how they can streamline the system itself and make it more efficient, so that those costs and so on, which Mr. O'Brien referred to earlier, that they can be targeted and savings can be found from there. So that's just a response to those 2 points.
No, to be fair, just to respond, I appreciate that, and I'm one who has said for a long time that there needs to be a review of the overall justice system.
Yes.
To see if there can be savings found within, for example, the delays within the court proceedings.
Exactly.
And delays between the public prosecution service and the courts. So it does need an overall review, and I've said that for a long time, instead of the piecemeal procedure, sorry.
Yes. No, I'm aware of that, Mr. Yes.
In relation to the second half of your question, the issue of who the cuts to either side of the profession will impact upon either side of the profession when cuts are made. We're not here to argue on behalf of the bar. The bar do a good job. We brief the bar. We use them. We only use them because they do a good job. And obviously any cuts to the bar would have an impact upon them. All we can really talk about is the impact of a further 27% cut on top of a 54% cut imposed in 2011 would have upon our practices and on the wider community. Because you have to remember that this is not attacking solicitors. It's not fat cat solicitors getting cut. This is solicitors in different areas in different towns getting less income, which means they'll have to lay off staff. That member of staff lives and works usually within the area where the solicitor's firm is based. They can't afford then. The knock-on effect, the ripple effect of these cuts are huge. Because if you lay off staff, they then can't spend money in the local community. They don't go and buy their sandwiches in the local shop. They don't get their cup of coffee in the local shop. The impact of cuts have a huge ripple effect. And the point about Solicitors Against Barristers is we employ a large number of people within our firms. We have to lay those people off. That has a major impact, not only upon the firm itself, but upon the local economy, because the local area suffers as a result of those cuts.
I was going to pick up on Pierce's point and say that Invest NI found that we added 5,500 jobs to the economy, which amounted to 330 million. So it's not an insignificant industry.
Can I ask one final question, Justin? Nobody seems to be able to answer this, and I'm not sure you can either, but anyway, I'll ask it. And that is in relation to the difference between the cost of prosecuting a case and the cost of defending a case. Have you any idea the relationship between those two costs?
I think that the question can be answered by somebody, but not by us, I have to say. The only simple way of looking at it, I suppose, would be the cost of the public prosecution service added on the cost of the Forensic Science Agency. Well, actually, let me retract the first answer. It probably can't be answered for this reason. A prosecution involves a number of different agencies. It involves the police in the first place. There's no specific cost as to how much police cost for each prosecution. It then involves the PPS. The PPS may involve experts such as the Forensic Science Agency. So it's impossible to work out exactly how much each of those cost. You can take a blunt instrument will look at how much the PPS cost per year and how much legal aid to defence services cost per year. Will give you some indication. And what we say is further cuts to the Crown Court system will lead to an inequality of arms in the situation whereby the state will have the resources of the police, of the Forensic Science Agency, of the PPS, and the defence services will be cut back by a further 27%, meaning that it won't be a situation which provides a fair system of justice to the defendant.
Okay, thanks, Chair.
Mr. Humphrey.
Thanks, Chair, and thanks very much. Excuse me for your presentation and your patience. Mr. Hunter, I hear what you say about the justice system, and in fact I have a number of friends who are solicitors and was on holiday with a group of people in August, and two of them are practicing solicitors, and one of them heavily involved in your organisation, and they were very, very adamant and made very many of the points that you make. But whilst I absolutely sympathise with them, and I have party colleagues who are young barristers and young solicitors who are in the predicament that you've all articulated, as did the Bar Council, is the situation just simply the case that there are not too many solicitors in Northern Ireland?
No. To answer that, no, there's not.
Well, if that's the answer, right, okay. I thought that's what you would say. Then how are we dealing with the situation that Mr. Hunter described of so many young solicitors standing there who can't get work? And a lot of solicitors, some of whom I know, young solicitors, who have been laid off.
Well, I suppose no was too definitive an answer. What we're saying is basically that it would be unfair in any society to cut off an area of professional employment for young people coming through the system. The difficulty is that if you cut away all of the public funded element of the criminal justice system, it means that there's less work out there for solicitors, for young solicitors in particular. So what we're saying is that as a profession, we believe that we don't close the door, we don't pull up the drawbridge, we allow people to qualify and become solicitors. There will be unemployed solicitors. There are unemployed solicitors. There are quite a few unemployed solicitors at the present time. And part of the factor in that is recession. Part of the factor in that is the fact that there have been major cuts made to the criminal justice system. And what we say is any further cuts will lead to more unemployment of solicitors. There's certainly an argument, and I can see where you're coming from. What you're saying is, is there just too many solicitors? That doesn't deal with the issue of the cuts to criminal legal aid. What we're saying is that the system requires a certain number of solicitors for Crown Court practices. If you cut back, that won't be able to be provided. So a further cut will lead to reduction within that area. We're not saying that we say there's enough solicitors. The work requires a certain number of solicitors, and they're not too many for that purpose, basically.
Well, it is the case that not all solicitors are criminal lawyers.
That's correct.
And so therefore not all companies actually practice or specialise in criminal law. It's not the case that most solicitors are really dealing with everyday things like conveyancing and wills and that sort of thing. So you know, even if you take aside what you're talking about in terms of the criminal end of things and money coming from the state in relation to that, do we still not have too many solicitors? And that's where we're getting to the point where the number of young people applying to go into the institute is going down because that's beginning to permeate through, and people are beginning to realise that.
I think the answer to your question is it's a much broader question than the issue of Crown Court cuts. The question is, have we too many solicitors? It's a very interesting question. I think at the minute the arrival of firms such as Alan Overy and Herbert Smith and the new firm coming from Chicago is a very interesting development, which the government and this administration through Invest NI has funded, has given money to these organisations to come over here and create employment. And they have created employment. They've employed a large number of young solicitors to do work which doesn't relate to Northern Ireland at all. It's to work outside of this situation, out of the system. But the government clearly has indicated that they're prepared to fund that through Invest NI. I don't really know the answer to your question. Perhaps Alan or Peter from the Law Society are better placed to answer that question. I'll go back to the point you make again, is that what we're here to talk about today is the cuts to Crown Court fees and how that impacts upon solicitors' firms. And we say that leads to reduction in employment opportunities. But perhaps Mr. Hunter can answer in relation to the whole issue of solicitors.
As Pierce says, that's a very complex question, and I'm sure you've debated it on holiday, and we could debate it here.
Many times.
I think what we're talking about in this context, though, is the availability of high quality practitioners to be available to conduct criminal legal aid work. You will see in the mixed practice, both in the cities and rural, you will see a mixed practice of all types of work. Yes, you will. But I can tell you that there are firms who have laid people off after the last result of cuts in their criminal section. So it is a very complicated question in terms of what you're describing. There's a lot of work going on in terms of increasing the legal economy in Northern Ireland, and that's certainly picking up some of the slack. But it's a long-term, medium to long-term piece of work. And there are various factors across a whole range of what a firm may do. Sometimes when young people are laid off after their period, they sometimes then join other firms. They sometimes, after a period, open their own firms and go into different types of work. So it's a very moving, dynamic environment. But what I think we're concentrating on here is the availability of practitioners with experience and commitment to conduct this type of work on behalf of the private citizen.
What was the response when you put these points to the Minister?
The Minister, I think, and Pearse has already touched on this, would like to have some, would like us to conduct some exercise that would provide him with statistics and so on. But our point to him was and is that it is for the government to assess the impact of its policy proposals. We simply don't have the facility to do that. But if government is going to propose this level of cuts, again, I mean 54% in 2011, another 27% in 2014. I mean, the policies and procedures are that government must know what the impact of that is going to be. We've offered to assist, we've offered to contribute to that, but we can't be in the driving seat for that for a whole host of reasons we can't. And so what we say is that piece of work needs to be done, but we also say that piece of work can't be done until the full effect of the previous cuts in 2011 have washed through.
And that point having been made to him then, has there been a follow-up or a further response from the Minister in relation to the point that you made?
I am not aware of that point being taken forward.
When did you make the suggestion to the Minister?
That suggestion was made to the Minister certainly in meetings we had when the paper was first published. Isn't that right, Peter?
Possibly this.
Yeah.
6-8 months ago.
So we say that what is
16 months ago?
Yeah, I would have thought it was that.
6 to 8 or 16?
6 to 8 months.
Okay.
Just on your point, Mr. Humphreys, I knew there was somewhere that we had some stats on the lawyering. In our response to the government's consultation paper, the Society notes that whilst it was felt in England and Wales there may have been room for contraction in the legal services market, according to the EU Justice Scoreboard report in 2013, Northern Ireland has the lowest number of lawyers per 100,000 inhabitants in the EU, according to their stats. And consequently, we did not feel there was an argument that we were over-lawyered. Just on that basis.
I accept that, but it just seems to be when there are so many young people who choose to go into the legal profession and they're not being able to practice it in the way they want, whether as lawyers or barristers, or see it as the career they would want to see as a path develop as quickly as possible, that is clearly an issue, and particularly an issue for those young people. But can I just go back to the Minister, and you suggested 6 or 8 months ago and no response yet. I mean, how long is it going to be left before you're going to pursue that with the Minister? Because I think that's vital.
I think the Department's response to us has been that that's for us to do and that we should produce the evidence and provide it to him.
Okay.
We're at odds with him on that because it's not something that we can facilitate or do for a whole host of reasons. Okay. But what we say is that that's clearly a responsibility of the Department.
May I say the Sujani report may provide the committee with some of the information that you're looking for. But I mean, stepping back from the whole issue, I appreciate and I think it's a positive thing that the committee is concerned about what the impact of cuts are to the profession. But I raised the question with the committee, if the committee found that there were 5 people left in the Bar Library and 10 firms left across the province, is that sufficient for the committee to conclude that there's an impact to justice? I mean, I would have thought that it is the committee's concern overall to look at really what the level of confidence that there is in the system, and that's something that's quite difficult to, I suppose, assess and to get a grasp of. And certainly impact of these cuts to the solicitors' profession and to the bar is certainly a piece of evidence. But I wonder how well the committee would be informed by the level of impact. You know, if, for instance, there are 50% less firms doing this type of work across the province, is basically the committee concluding then that there is an impact to justice? So I'm putting that query there because I suspect it hasn't been something that's been fully thought through.
Well, I am aware, speaking to friends and party colleagues, that there are a number of firms currently under pressure, and a number of firms, obviously, a considerable number of firms who have closed. I'm aware of that. Can I ask you finally, in terms of your conversations with the law societies and the rest of this jurisdiction in the Irish Republic, what sort of pressures are they feeling? Similar pressures?
Well, there's a general pressure, I suppose, across the Western world, if you like, in relation to legal aid expenditure. But we haven't certainly done comparisons, if you like, between this jurisdiction and the Republic of Ireland. I suppose we would have more awareness of what's happening in England and Wales simply because the Department have utilised that jurisdiction as being the comparator in respect of the effect of these cuts. And our position obviously is that England and Wales is not an example that we should aspire to.
Thanks, Jim. Thank you.
Thank you. And I take the point about the committee trying to impact all of this, although it does put the committee in a pretty invidious position that the department, you're saying, hasn't properly impacted it. The Law Society don't feel it's their job to do it. And so it becomes subjective for us, and therein lies part of the problem. And we have to take into account then the Law Society says this has been devastation, followed up with in the same very presentation now we've just had, but we don't really know because we can't really assess the full impact. So I would just be careful about the language that's used, and then when we ask, show us the evidence, well, it's not really our job to do that, but you've used statements to suggest devastation. So we have to weigh these things up and try and reach a decision on it as best as we can.
In fairness, Mr. Chairman, I think that doesn't necessarily follow in this sense. The job of any government department when bringing in proposals to make cuts is to do a regulatory impact assessment on how this will impact upon society, upon certain sections of society, and upon the service providers, which are solicitors. We have been saying to the Department of Justice, and have said from the very start, that the previous cuts have had a major impact, and further cuts will have a major impact. It's a government's job under regulatory impact assessment to assess the impact and to come back and say this will have no impact. And they haven't actually done any work on this, which is what they have done in their RQIA. It says, sorry, RIA said this will have no impact, is wrong. So you're not quite in the situation. You should surely be asking the Department of Justice, well, what work have you done with regard to the impact this will have upon small businesses and small firms and local communities?
And what has been admitted by the Department is that these cuts haven't washed through the system, and they won't do so until 2015, 2016.
But I certainly don't get a sense that there has been carnage and devastation in terms of what happened in 2011, and that's what's been stated. These cuts have been devastating. Now, I don't get that sense that the cuts that we put through in 2011 has caused devastation. So it's a little bit like the story that we all learned about the little boy that cried wolf. And I would just caution about the statements that are made, because I heard the statement at the time we would get yellow pack justice. Didn't happen. I'm hearing a statement again today, devastation. That's not my sense. So we do our best to decipher information from the Department, from the Law Society and from the Bar Council, but ultimately we'll need to reach a decision on it. And up until this point, there hasn't been a single occasion where the professional bodies haven't been able to work with the Department and the Department haven't been able to work with the professional bodies. And I have sympathy with the Department and I have sympathy with the professions. But we'll ultimately need to reach a determination whenever it comes to this committee to look at.
May I just make one point, Chairman? What we have said to the Department very clearly is that there requires to be a review, because as the figures Mr. O'Brien gave illustrate that a lot of the additional expense in the justice system doesn't arise through payments to lawyers, it arises elsewhere. But what we've said to the department is that we will cooperate with them and contribute to a review of the system. I mean, if you look at any business and you have to make cuts, you know, you might put in a pay freeze or whatever. You might do something like that. But generally, what you'll do is you'll do a business process re-engineering investigation, and you'll see how you can do what you can do more efficiently. What we're saying is that has been absent from the Department of Justice's agenda. But what we've said to the department and said to the Minister very clearly is that we will certainly contribute and cooperate in that exercise, and that's where we would like to see this discussion go, because we're saying that that's where the efficiencies and savings can now actually be made, following upon the original cuts.
Yeah, but from my perspective, it's only been from 2011 when the cuts came in that I see a real determination to let's look at getting a better system. And maybe it's going to take another set of cuts for the professional bodies and the department to get the efficient and effective system, because we can't keep using the excuse of let's not have changes in fees and all of that, let's try and get this efficient, effective system unless something is the catalyst that actually forces it. And members will have to weigh that up whenever it comes to this committee. And this committee, I have to say, has stretched itself, I think, to actually get information. That's why we're getting Sajini to look at it. And we are going the extra mile because we're not getting a unified approach from the professional bodies in the department. So we're doing our best, but ultimately we'll need to reach a decision. And I've met with countless solicitors. I know many of them in my own constituency. I see what they do. I know the good work that takes place. I have friends that are barristers who are very lowly paid barristers. I know all of that from a personal point of view. But we still have to reach decisions on it. And it's very difficult for us to do that. And we have a financial context which is very challenging for the department as well. And I also have friends who are waiting to get operations on the health service, and they come to me and are blaming me for not being able to get that operation. So there's all priorities that need to be weighed up in terms of our expenditure. And some members have indicated while I've been talking. So let me bring them in, and then we'll wind this one up. Mr. Anderson.
Just quickly, Chair, you've touched on most of it, so is my colleague, Mr. Humphrey. Your society represents what is 2,600 solicitors, 570 firms at the present, right across Northern Ireland.
Yes.
And what we're saying here is, how many firms who you represent have closed down? How many have closed down right across Northern Ireland since these cuts came in 2011? Do we know?
No, we don't know.
If you don't know, why shouldn't you know? You do represent them.
Well, we go back to the point that the chairman raised in relation to his points that we want the department and we want the societies to get together to change the system. And if I could just refer to that point, it is for the department to change the system. The societies of the professions don't have control of the system. We react to it, we do the best that we can in representing the client, or our clients, but we don't operate this system. So when you come to apply cuts, or when the department come to apply cuts, they're applying cuts to one element of this system. They're not applying cuts, as I see it, anywhere else within that system, and there is not as yet a proposal to actually radically change the system. So far, we've had a multitude of reviews, consultations, proposals, and they all centre around essentially an attempt to bring legal aid within a certain budget. It's all a budgetary crisis. It's not an overall look at the system.
But Arlene, the question I'm asking is, how many solicitors have lifted the phone and said to you that you represent them and said, look, next week I'm laying off 2 staff, following week I'm laying off, or how many people, or I'm closing this business altogether? Surely you must know, since 2011, how many is closed down throughout Northern Ireland, how many people have left the profession that you represent. Now I understand that there's others who you don't represent throughout, and as the Chair says, we all know many solicitors firms and the work that they do. But I just find it hard to get my head around that you don't know since 2011, because of the cuts, that they have lifted and contacted you and says this is what has happened because of what was brought in 2011. Can you tell us a ballpark figure, any idea?
No.
The fact of the matter is that firms are closing all the time, they're reconstituting in a different format, and firms are opening all the time. So it's not a sort of a fixed point in time evaluation. There has been a reduction, I think, in the number of firms overall. I can tell you that the number of practicing certificates of practicing solicitors over the past 5 years has probably increased by about 300. The number of people who have qualified as solicitors is probably about 170 each year. So you can tell from that the number of people who are qualifying, the number of people who aren't coming through, and why it is that we don't have specific figures in terms of
Yeah,
firms
but
that have closed.
I'm still coming back to the point. If you represent a certain number of solicitors, whatever what the figure is, and 5 of them close down, surely they tell you, we've quit our business. Surely you should know that. If it happened in any other business, you would know that. You're telling us today you don't know, you have no figures.
But the society isn't any other business. We're a representative body. This is not.
But all your members.
We're saying we don't run a department as such, so we can't say to you specifically there are X numbers and X amount of people have had a reduction in their wages. It's a
If I'm a
private.
solicitor down in my hometown,
What are you doing?
and you represent, I'm part of it, the society represents me, and I am about to close here next week. Surely I would let you know that I'm closing my business and there's going to be so many staff go with me. Surely there has to. I think what you're telling us today, you don't even know what has happened in relation to the cuts. And specifically what I'd like to hone down on is the firms that's dealing specifically, say, with maybe more so with the legal aid aspect. You haven't not even decided to tell us what it is.
Well, let me as a practitioner and not a member of the staff of the law side, I'll try to answer your question in this sense. We're all businesses and we're competitive businesses. So what you don't want to do, what you don't want to have gone out there into the world and to our clients here is that, they're in trouble. They've had a round of redundancies, they've laid off 2 solicitors, they've laid off 3 secretaries. That gets out in the wider community, and believe it or not, clients pick up on these things. They go,
comes everywhere else.
Yeah, exactly. They go, they're in trouble. They're in trouble. I'll not go to them. So solicitors are very protective of their own business. They don't broadcast. They don't redundancy returns. I know. I was talking to 3 separate solicitors today who are all involved in the redundancy process. None of whom have told hardly anybody they're doing this process. We're very protective of our business, and the reason we are is because the damage to your business, if it gets out there that you're in difficulty, is phenomenal. So that's from a practical practitioner's point of view. The firm itself may still exist, but it'll be a differently constituted firm than that which was there 3 or 4 years ago.
But
part of that is a business reason.
Stop you as a society to know the numbers. You don't have to say who the people are. You can say, look, 20 firms closed down last year. So many left the profession last year. We don't have those. And you are the society, you represent so many people, and you can't tell us how it affected since 2011.
No, we can't. And we're saying that it's the department's responsibility.
I think that's what we need to know.
To carry out an impact assessment to see what the effect of these cuts have been. And hopefully the report by Sujini may help shed some light on that.
I think we could talk about this for a long time, but I think really I'd like to see figures what has happened over this last and how many firms and staff have really been truly affected by the effects of these cuts. I don't think that is coming through here so well.
Ms McCorley.
Just in relation to a point raised by the Chair was what I was going to ask. This is a difficult task for us. We've been listening to evidence now for some time, and it's difficult, when you're not in the profession, to understand exactly what is happening, and because you're hearing so many different sides and aspects. But we will be hearing from Sujini. As you know, they've been asked to inquire into this. Would you be confident that they will produce responses that will reflect your concerns?
I'd be very surprised if it did not.
Okay.
And don't know if it's the best to last, but it is Mr. Wells.
Well, you'll definitely not be calling me a good MLA after this, I can assure you. In 2011, I was on this committee, and we were told there was going to be Armageddon, there was going to be blood on the floor, there was going to be wholesale solicitors firms closing. And I think Mr. Anderson's comments were very apposite, because you would have thought, well, if that had been the case, that your society would have had very concrete statistics showing that we have lost 100 solicitors' firms. We've had 75 solicitors retire, take early retirement or resign. And yet there's no evidence of it. And Mrs. Elliott, you said something quite significant. You said that despite those cuts in 2011, you still have no problems getting and instructing counsel to represent your clients.
Yes, that's the case.
Well, I appreciate your honesty, because that's not the message we were getting earlier on. So in other words, despite these savage cuts, there are still people out there perfectly happy at junior and senior counsel level to represent your candidates in the court, your clients in the courts.
Yes.
So much for the impact that the original cuts had. So why, therefore, should we believe what we're being told now?
Well, I can't comment on the bar's position, and you've already heard from them in respect of that. But what I'm saying in relation to the impact on solicitors' firms is that it's a much more, there certainly has been impact, because common sense would tell you that if you have to deal with cuts to fees in respect of a body of work that comes into your office, of which you would anticipate getting on an annual basis, you have to then look to see how you deal with those cuts. And when I answered Ms McCorley's question earlier, I gave an example of the different range of options that's available to any solicitor in respect of how they deal with that. And that can range from not doing the work down to the sort of cuts that you have to make within your business. And those sort of those decisions are tough ones, and they're not unusual for anybody within the business community. And I am sure people here have or entirely appreciate that from your constituency work. So, you know, you're asking me again to basically give facts and figures in respect
which might be useful.
The levels of redundancy and figures.
Yes.
And you know, I will say again that we do not hold facts and figures in respect of redundancies and cuts. But given that this is the department's proposal to implement further cuts, what I'm saying is that it seems to me that there should at least be a period of reflection until the first round of cuts in 2011 have washed through the system before implementing or considering implementing another round of cuts. I mean, how do you know what the impact is to the system?
Well, we don't, because you can't give us the figures. And every other professional body that I deal with, like the RCA and the BMA, could give you to the last man how many people they have registered with them, how many have left the profession, how many have come into it. And yet here we have the premier body representing 526 firms, and you can't give me one single statistic to show the impact of the 2011 cuts on the number of heads who are doing legal representation in Northern Ireland.
Well, Mr Hunter's already given you figures in relation to the practising certificates.
That's not what I'm
But
after.
that's different to the sort of impact or the sort of measures that might be taken by various firms within the community.
And I'm absolutely aghast that you haven't done a survey of your members to produce this. Simply write out all 500 and say, give us statistical proof that the 2011 cuts have had any impact whatsoever. Now, because some of what you're telling me are also affecting solicitors who do little or no legal aid work, and it's because the recession. Conveyancing, which is the bread and butter of many rural solicitors, has dropped through the floor. And I know solicitors' firms in my own constituency who are doing a third of the work they were doing 6 years ago. Nothing to do with legal aid cuts. So you have to factor in that aspect, which has nothing to do with what David Ford did. And I'm just surprised, I really am surprised that a professional organisation as yourself cannot produce that information.
I think it's much more complex than simply, you know, the number of firms in 2011, the number of firms in 2014. I mean, during that period, there's a whole host of factors that have come into play. What I do know from speaking to people is that during that period, those involved in criminal practice have certainly laid off some of their frontline solicitors, have certainly laid off some of their back office staff as well. This is not information that people are terribly, as for reasons which Mr McDermott explains, keen to publicise. The figures which we hold are holistic and wouldn't gravitate into this kind of detail. It's as simple as that.
Well, I think you should have done that survey, but that's entirely a matter for yourselves. It does weaken your case.
Well, except for this, that we did offer to cooperate with the department in this work. So
I don't see it's the department's role, frankly, to produce information to show that their so-called cuts are affecting your members. It's up to you to show quite clearly that's what's happening. I don't think I'm going to win this argument, so I don't want to labour it, but it just is a major flaw in your argument. And why this is important is that if you haven't got that information for the 2011 situation, how can we trust your assessment of 2014? Because as like the chairman says, I do not see on the ground what was predicted when the standoff was occurring in 2011. Also, when you're faced with reductions in your legal aid income, you don't have to cut the service. You could do what an ordinary company would do. You could work harder, you could work more efficiently, you could work more intelligent, you could reduce top-level pay for your senior partners, or you could diversify. So why are you automatically assuming that a cut in legal aid should mean a deterioration in your company when you've got all those options, and I don't seem to see any evidence of it, any of those being taken? Have you been cutting senior partners' pay in Solicitor's Office?
The answer to that is yes, substantially. But I think you're actually, we make the point that cuts have an impact upon solicitors' firms. You don't accept that. I can tell you, and I hate talking about personal because I don't like, but in our firm in 2010, we had a third less staff, solicitors administration. Third less from 2010 to 2014. Okay? I'm not going into detail, but it's telling you that's exactly right, a third less. That's one for...
What's that to do with legal aid rather than conveyancing?
Well, how do you ever work that out?
Well, look, that's for you to work it out and tell me.
Well, I could tell you, but I don't want to go into a personalised firm. I don't want to.
Generally, you should tell me how much of this loss...
I would say, of that third, I would say about a third of the third was recession and about two-thirds was legal aid cuts. On that level. But what I'm going to come to is a point that I think we can get lost in the point about looking at individual solicitors' firms, looking at individual profit. What you have to be looking at is, do you want to fund the criminal justice system properly, or do you not want to fund the criminal justice system properly? And that's the issue, and that's a societal issue, and that's where we keep getting lost in the details.
I think the state should fund legal aid to the level that can produce an adequate level of representation at the lowest possible price to the taxpayer. Nothing more. And the market's telling me at the moment that is still being done. I am not here, and the state is not here, to give solicitors, barristers and QCs an inflated salary. We're here to get the best possible representation at the lowest possible price. And you haven't convinced me or shown me a single statistic to show that isn't the case at the moment.
Well, that is working its way through a system whereby, because under the current regime, the abolition of under the current proposals, the abolition of GP2s and the abolition of the pays crown fee will mean that those large cases, like the Haddock trial I was talking about earlier, won't be done by firms. They won't be done because the level of remuneration will not be sufficient to allow the hours to put into that case that are required. Now, that hasn't happened yet because those cuts aren't in place yet, but they're proposals and they're proposed to be cut. If they come in, that will happen, as has happened in England, whereby council has said, I'm not doing this big fraud case because I can't get properly paid for it.
Does it not embarrass you, Mr McDermott, when you see some of the fees that the QCs and junior counsel are picking up as a result of your referral of cases?
It's a matter in, what happens with regard to counsel getting paid is not my concern as a solicitor. It's my concern as a citizen, possibly, but not as a solicitor. But I think you're still missing the issue that I'm trying to raise with you. You're saying you want the lowest common denominator type of justice.
I want the lowest possible price for adequate representation.
But both of those things don't necessarily flow. Because what happens is once you get the lowest fee level, you don't get the quality representation that you require. And that's the problem with it. And what is happening with the current proposal is it's going to bring down that system further. And just to pick up a point the Chairman made, in a similar vein about disaster, the reason that there hasn't been disaster is due to the good offices of the solicitors and the barristers in this jurisdiction, who are working in criminal cases on a non-profit basis half the time. Because they're not getting paid properly for it, but they still do the work because they're professionals. And don't underestimate the fact that we are professionals. And it's very important. But you don't pay someone. We didn't go through 7 years of education and 2 years in apprenticeship. They end up getting paid nothing. We are professional people who work very hard at our job and represent our clients to the best of our ability. We don't get paid for the mentally handicapped, nearly mentally handicapped client who stands at my door every day. I have to take him over to Corporate Street to get his benefit. I don't get paid for that. But we do need to get paid for the professional duty we do in society, and it's important in a civilised society that you prepare and you pay properly for a defence service.
And would you do that for an excellent salary rather than a fabulous salary?
I'm getting neither excellent or fabulous.
Well, the tables that we see on the legal aid payments to both solicitors and barristers tell a different story.
Well, let me talk about solicitors, because the figures for solicitors are completely meaningless. What does that tell you?
Kevin Winters, 2 million.
What does that tell you?
Madden and Punduk at 1.6 million.
What does that actually tell you?
That they're getting an absolute
How
fortune.
do you know how many people they employ? How do you know how many cases they've done? How do you know how many clients they've represented? You have no idea.
East McDermott, £800,000.
You have no idea about solicitors' firms, what those figures mean.
Mr. Berry, £1 million. Any standard for 1 year's work is fabulous money.
Well, the first point to make is it's probably not 1 year's work, because the way the legal aid service works.
Average of 800,000.
I'm here to talk about solicitors, and I keep making a point to you.
Can I say, Chairman, we're only here to answer questions in relation to solicitors.
Right, Kevin
We can't
Winters, 2 million.
answer
And I
in
repeat
relation
again, the figures
to
are
the
meaningless
council.
because you don't know how many. And we've asked the Legal Service Commission to give us a breakdown and give a proper breakdown of the number of cases, the different types of area that involves, so that you can actually properly assess those figures. You've no idea how many cases are involved in that. Do you read the papers? Many clients that Kevin Winters, George Galloway, there you go, he represents George Galloway. Kevin Winters' firms represent a huge number of clients, they do a huge number of cases, therefore they are a huge earner. Tuckers in England earn more in profit than the entire legal aid budget for Northern Ireland. It's one firm. You don't know the volume of work, so the figures are meaningless.
But why this is important is that what we're arguing about here, the total amount of money, is the legal aid gained by 3 solicitors' firms, only 3 solicitors' firms in Northern Ireland. 3! That's the entire saving of what the Department of Justice are looking. That puts it into context. 3 out of 526.
It doesn't put it in context when you have no idea what those figures mean. They're absolutely meaningless. There's no breakdown of the number of cases undertaken by that firm, the number of employees in that firm, the number of clients they represent, and without that breakdown, the figure is meaningless.
I'll finish with this because I've had a fair crack at it. So you're perfectly happy that it's possible for someone who this last 4 years in Northern Ireland to earn £800,000 average as a result of criminal legal aid in this country?
Again, that's a question that's more appropriate for the bar.
Well, the point was made earlier, there's the solicitors who make the who take on the counsel, so there are 2 that are interlinked, but you don't need to answer the question.
No.
Okay, that's fine. Mr. Humphrey, you for final.
Can I just come back, and I make this point to try and be helpful. You have to understand from the perspective that we come at here, and having listened to the evidence from the Bar Council and now yourselves representing solicitors in Northern Ireland, and I appreciate the difficulties and the pressures you're under. But you are identifying, Pierce, that in terms of when you look at figures, you can't extrapolate the work related to the workload related to the figures. You have to understand that if I find it amazing, I have to say, to be honest with you, that the Law Society of Northern Ireland is not in a position to tell us how many firms have closed and how many solicitors have lost their jobs or how many have taken early retirement. As a representative of what I would have expected when there are 500 firms, I mean, I drive past your building quite regularly in the city centre. I presume you have a secretariat in that building. Surely you, because I make the point because we need to know if we are to assist you in what you want us to do, that those people have been laid off because of the cutbacks that you're talking about. And we're debating here today, or is it because of the economic downturn and the recession and the fact that, you know, construction industry, house building has had a major slowdown, and so therefore that affects conveyancing and so on. We can't do that if we don't have those figures. And I really do not think, to be with all due respect to you, I do not think that's the department's job to do that. Because, you know, a trade union will, and we meet trade unions on a regular basis in relation to job cuts in our constituency or potential job cuts, they will tell you down to the nth how many people have lost or potentially will lose jobs. And I really do think, you know, the Law Society should be in a position to do that as well. And make that point to try and be helpful, because it would help us to make the case.
Okay. Can I thank you very much for coming to the committee? Your time is much appreciated. Thank you. Okay, members, if you're content, we'll ask the department to respond to both the session of the Bar Council and the Law Society and see the points that have been raised. And it'll come back to us when we get the Sagini report which we've asked for, so we'll revisit it. Mr. Elliott?
Chair, I was just thinking there was queries raised around individual firms and cases. I wonder, could the Legal Services Commission give us any further breakdown of those? They may not be able to do, but it might be useful to ask, especially in relation to the number of cases that that each of those figures related to.
Well, we could ask the Legal Services Commission, are they able to break down
Yeah, they may not, but
the figures that they have for the
maybe useful at
solicitors?
least to ask.
Okay.
And again, I don't know whether this is, it's probably not possible for our Assembly Research team, but if there was any chance of them being able to give us some sort of level of figures within the legal professions in the last number of years. Now again, it doesn't break it down then into whether there's 50 less because of the recession and because of legal aid, but it may give us an indication of what way the numbers in the legal profession are going.
Well,
Are they actually going
we
up?
can ask them if they can look at that to find.
Okay, appreciate that.
Okay. Okay, members, we've quite a lot of routine business to get through, but if you work with me, I'll try to get through it as quickly as possible. Item number 6, Human Trafficking and Exploitation Bill. Following the update provided by officials last week on the further work that's been carried out in conjunction with Lord Morrow in relation to the Human Trafficking Bill, since the completion of the committee stage, the committee agreed to consider the additional amendments being proposed with a view to establishing whether the committee's content to support some or indeed all of them. And I've worked through the table is probably the best way to look at this, which is on pages 108 through to 132. I don't intend to deal with the clauses. For example, clause 6, obviously that was dealt with previously, but it's only on the amendments where I'll borrow yours, Christine, if that's all right. So obviously there was clause 1, and that then related through to clauses 1A, B, C and D, and the committee had previously indicated we were content with clause 1. So if the committee is content with the amendments, then we can record that. Then there was clause 2, and that led then to clause 2A, which again the committee had indicated previous consent to, so if members are content. Then it went to clause 5, which then related to clauses 5A, B, C, and that related also to Schedule 2. Then there was a 5D, and that related to Schedule 3, and then there was E, F and G, and members had indicated previously contentment last week to that. Yeah. So unless members have any issues, we can get content. Clause 7. We were content with previously. We're still content then, we'll indicate. That was clause 5G, replaced clause 7. Again, clause 12. Like, is there any of the, maybe it's easier, are there any amendments that where Lord Morrow and the Minister have reached agreement on that members are now no longer content with? Because that might speed things up. Yeah. Okay. Is there anything we need to cover then?
Sure, there's nothing further in clause 12A. I know there are still some discussions ongoing.
No, they're still working on clause A, so I'm assuming they'll come back to us when they make some progress. And they're also being back on
the rapporteur,
Anti-Slavery Commissioner, rapporteur. If they decide to present an LCM, they'll have to come to committee on that. So,
sure, come back to that one then.
Yeah, this will finish the committee. If they come, the rapporteur issue and 12A will have to be dealt with now whenever it gets to consideration stage, given the timings of everything. So once this is finished today, the committee will really
doesn't have any more role to play.
Yeah, unless members should know the position at the minute.
Yeah, not at all. Okay, well, I think what would be useful, we'd already done the report. I think it would be helpful if we would, and that was sent to every MLA, and I think it would be helpful that we would send a letter to the MLAs to show here's where Lord Morrow and the Minister has reached agreement, and the committee had previously had a view on the amendments, and the committee is now still content with the revised amendments where they had reached agreement with, and help to lay that out for members so that they're aware, because it is quite a change from what originally was there. So I think that would be useful if members we would do that.
Yeah.
And obviously the outstanding issues will just have to be dealt with now as they arise in the Assembly. Okay. Item 7 then. At our meeting on the 2nd of July, we agreed to refer the Justice Bill to the Assembly Examiner of Statutory Rules and request a report highlighting any delegated powers to which he wished to draw attention to. The Examiner has provided his report and has raised an issue in relation to the regulation-making powers in clauses 79(2), the general duty to progress criminal proceedings, and clause 80, which is case management regulations. So if members are agreeable, we'll refer the issue raised by the Examiner of Statutory Rules to the Department of Justice for a response. A paper providing an update on the written submission received is at pages 71 to 77 of the table pack. There are a total of 45 written submissions from organisations to the Justice Bill. Of the 45 written submissions, 22 commented on the bill, 11 commented on the Department's amendments, 3 commented on the Attorney General's amendments, and 24 commented on Mr Wells's amendments. A number of responses from individuals in support of Mr Wells's amendment have also been received, and they are outlined in the table document. And just to inform members, the written submissions now to the bill and these amendments are all currently being uploaded to members' electronic bill packs, and hard copy of submissions available to the committee office can take place if members wish to do that. So we'll have a finalised, detailed breakdown of all of the exact responses for next week. There's just exact details of that still to be dealt with, and then if members are agreeable, we'll deal with that in the normal way. We'll publish it in the committee webpage, and obviously the key issues that are raised in the submissions will be provided to the committee in due course, and then proposals for oral evidence sessions will have to be considered by the committee, and that we'll consider those over the next number of weeks once that analysis of the responses is carried out. So are members content then that we would publish the written responses on the committee bill web page? Yeah. Item 8 is access to justice review part 2. The Minister has informed the committee in June this year of his intention to commission a further review of access to justice that would build on the reforms which have already been introduced or which are currently being taken forward. Mr Jim Daniel was subsequently appointed to complete the second review and wrote to the committee setting out his intended approach and timetable. Mr Daniel has now provided a copy of an agenda document which is intended to stimulate discussion about the matters covered in the review's terms of reference, and he is requesting written responses by the 30th of November to allow publication of the final report. Members will know we agreed at our meeting on the 11th of June for Mr Daniel to attend on the 22nd of October to brief the committee on the review, and this will provide an opportunity to discuss the agenda document and the key issues that are to be covered. Item 9's revised proposals by way of the operation of the Northern Ireland Crime Agency and potential legislative consent motion. So members will know the Minister has provided a paper setting out these revised proposals, and the Department has indicated in January 2013 that if there was agreement that could be reached, then the potential is there for an LCM to be brought forward. The latest paper indicates revised proposals would in many cases require legislation, so obviously members are aware of it within their own parties, so it's there for members to note. Item 10 is Access NI review of fees. At the beginning of June, the Department provided information to the Committee on Access NI's performance and key challenges that it faces over the next 12 to 15 months, and that includes a requirement for it to increase fees charged for applications for enhanced criminal records checks. The Department has now provided a briefing paper to the Committee to consider a proposed increase of enhanced check fees from £30 to £33. Cost of the standard and basic checks will remain unchanged, and there will be no fees for volunteers. A negative resolution statutory rule will be required to make the change, and the Minister is keen to seek views of the Committee on the proposed increase before the documentation is prepared. So based on the information that we've had, unless members plan to object to the statutory rule, we'll note the information, and obviously the Minister can bring it forward.
Chair, maybe no major difficulties with the increases, just the time delays. I'm sure other representatives get contacted about the delays in Access NI, and I think if they were up their performance rate, it would help. And it may be useful to ask them for a written briefing on that. I know it's nothing to do with the fees, Chair, but it's relative to their work. And it might be useful to ask them for a written briefing on the timescales of getting Access NI checks complete.
Okay, well, we can ask that, and I think there was information provided around some of their key performance indicators. I know I met with the Minister recently on this, and there certainly had been progress made on it, so we'll ask him to
report on their performance for 1st of April 2013 to the 31st of March 2014 in the pack.
The pack is at the starting at page 291. Is that one?
Page
308.
Yeah, 308.
You're okay. So there's some information there, so if you want to have a look at that one again,
Okay.
And if there's more information needed, we can certainly ask
Some
for
information on their performance last year, and also there's some information on revised performance targets they're bringing in.
Okay.
All right. Item 11 is consultation on the extension of the Offence of Domestic Violence Crime and Victims Act 2004. The Department has provided a briefing paper outlining its intention to conduct a targeted 8-week consultation on the possibility of extending existing legislation to include the offence of causing or allowing serious physical harm to a child or vulnerable adult. Legislation in England and Wales enables the joint conviction of members of a household who cause or allow a child or vulnerable adult to suffer serious physical harm in certain circumstances, but the provision does not exist in Northern Ireland. The Minister has decided that a consultation should take place with a view to including a provision in the current Justice Bill. So if members are content to note that there will be a targeted consultation on that particular issue. Item 12, Attorney General has required, as members know, under Section 8 of the Justice Act to issue guidance to named criminal justice organisations on their functions in a manner consistent with international human rights standards. The AG has now provided draft guidance for the Courts and Tribunal Service, which focuses on its role in supporting victims and witnesses. The guidance highlights that international standards of human rights law require that the perspective of the victim in the justice system be taken into account, and that the rights of the victim and the rights of the accused be balanced. In preparing the guidance, the attorney staff have liaised with the court service officials and, where possible, incorporated suggestions into the guidance. So I'm just seeking if members are content with the draft human rights guidance that has been prepared. Unless there's more information members need, then we can indicate our content. Obviously, the Attorney General will then lay the draft guidance in the Assembly and provide the Committee with details of the proposed statutory rule that will bring it into operation, and that will come to us in due course. A number of technical statutory rules, members, just for me to go through. At a meeting on the 16th of January, Committee considered the Court Rules Forward Work Programme for January to April of this year, noted 4 rules which proposed technical amendments to the existing court rules to ensure compliance with the EU Directive on the Right to Interpretation and Translation in Criminal Proceedings. 4 statutory rules have been laid now by the Department on the 15th of August. They're subject to negative resolution. The rules come into operation on the 5th of September. The Assembly Examiner of Stat Rules has confirmed that there are no issues in respect of technical aspects. And if I can look at each committee with the members, the Crown Court rules will amend rules related to 1979 to create the procedure to ascertain whether a defendant needs interpretation, provide a power for the court to deal with complaints about the provision of interpretation or translation, and provide a requirement for the court to record where interpretation is used and where a defendant waives the right to translation. So if members are content, I formally put the question that the Committee for Justice considered Statutory Rule SR 2014-219, Crown Court Amendment Rules Northern Ireland 2014, has no objection to the rule. Agreed?
Agreed.
And then the next rule will amend the rules of the Court of Judicature 1980 to make the same changes that I've just outlined previously. And if you're content, I'll put the question that the Committee for Justice considered Statutory Rule SR 2014-220, the rules of the Court of Judicature Northern Ireland 2014, and has no objection to the rule. Agreed?
Agreed.
Then there's rules that will amend the Magistrate Courts 1984 to make the same changes as previously indicated, and if members are content, I'll put the question that the Committee for Justice considered Statutory Rule SR 2014-221, the Magistrate Courts Amendment No. 2, Rules Northern Ireland 2014, and has no objection to the rule. Agreed? Then these rules will amend the Criminal Appeal Rules of 1968 to make the same changes previously outlined. And if members are content, I'll put the question that the Committee for Justice considered Statutory Rule SR 2014-222, Criminal Appeal Amendment Northern Ireland Rules 2014, and has no objection to the rule. Agreed. Then the Department is proposing to allow the Northern Ireland Court of Judicature Rules Committee to make amendments to Orders 22 and 106 of the Rules of Court of Judicature 1980 under its powers. Relevant to this, the proposed amendments to Order 22 are technical and consequential and are made in order to update references made to Order 25 of the Rules. Order 25 makes provision in relation to medical evidence. It was substantially amended and restructured in 2009. However, consequential technical amendments were not made at that time. The proposed amendments to Order 106 deal with the High Court proceedings relating to solicitors, including appeals from Solicitors Disciplinary Tribunal. The proposed amendments will remove the current rules requirement that a solicitor is anonymised in proceedings under the Solicitors Northern Ireland Order 76, where he or she is subject of an application to the High Court for delivery of a cash account or in other financial or property related matters, or there is an appeal from findings of the Solicitors Disciplinary Tribunal. The rule will be subject to negative resolution procedure. So unless members have any issues around that, then we can indicate that we're content with the proposed statutory rule, which will come forward then in due course. 18. Department's proposing to make a stat rule under powers that it has to establish a procedure for appeals against decisions on applications for funding and provide for the establishment and composition of independent appeals panels. This relates to the Legal Aid and Coroner's Courts Bill. The statutory rule is part of the suite of secondary legislation required to implement civil legal services. The rule is subject to draft affirmative resolution procedure, and it is proposed that the rule comes into operation on the 1st of April next year. The Department's document, which is in the meeting folder, sets out the principles of the appeals process and the new process. Subject to committee's agreement to the proposal, the Department intends to undertake a targeted consultation on the draft regulations with those consultees who previously expressed views on the appeals mechanism. So if members are content to note that information, unless there's any more clarity needed, we'll note it. Next item, the Department is proposing to make 2 statutory rules which are necessary as a result of the Legal Aid and Coroner's Courts Bill. The first rule is subject to affirmative resolution. It's in respect of civil legal services under powers conferred by the Access to Justice Order. It will make provision for legal representatives of persons in receipt of civil legal services to disclose information, notwithstanding the usual rules of legal professional privilege regarding disclosure of a client's information. It also sets out the circumstances in which information about people in receipt of civil legal aid may be disclosed by the legal aid agency as part of the department. Provisions also made to permit the disclosure of certain information for the purposes of the investigation and prosecution of offences, subject to safeguards to protect the rights of the assisted person. The second rule is also subject to affirmative resolution procedure. It's in respect of criminal legal aid and will set out circumstances in which information about people in receipt of criminal legal aid may be disclosed by the legal aid agency as part of the department. Provision will also be made to permit the disclosure of certain information for the purposes of the investigation and prosecution of offences, subject to safeguards to protect the rights of the assisted person. The Department again is proposing to undertake a short targeted consultation on draft regulations with key stakeholders. So if members are content with that information, unless there's any more clarity needed, we're content. Correspondence, there's 15 items. I'll draw attention to a number of them. Item 1 is a response from the Minister in relation to possible funding streams for Autism NI's Young People, Autism and Criminal Justice Project, which is currently funded by the Lottery Fund. If members are content, we'll forward that response to Autism NI for its information. Then there's an invitation from the Minister to an evening reception for International Law Enforcement Forum Conference delegates, and it's on Monday the 29th of September, and I'm afraid the international venue is Parliament Buildings, so if you want to go, you'll not have to travel far. And if you can advise the clerk, if you do plan to attend, that would be helpful. Then there's correspondence from 7 individuals about PSNI equal pay claim, which is asking the committee to write to the Minister of Finance and Personnel, NIO, Police Board, Department of Justice and PSNI. If members are content, we will forward these letters to those particular organisations, and then members, just to remind you that the committee did agree at last week's meeting that we would write to both the Minister of Finance and the Minister of Justice seeking an update on those issues which we're awaiting. Then there's an invitation from the Ulster Farmers Union to attend a conference on the issue of rural agricultural crime, and that's on Tuesday the 4th of November, and it's in Crumlin Road Jail. So if members wish to attend, if you can advise the clerk accordingly. Is there any comments on correspondence that I haven't mentioned? If not, we can agree to action as outlined. I have no chairman's business. Is there any other business? Okay, and we'll meet next Wednesday at 2 o'clock in the same room.
Northern Ireland Assembly, Committee Room 21.